At ito po ang The Chief Justice on Trial.
Samahan niyo mo kami sa pagtutok sa mga pinakuling pangyayari dyan po sa ating impeachment trial kung saan at sa Korte Suprema na rin dahil inaabangan na rin po yung paglabas ng resulta ng 2011 bar exams. Ayan.
Patuloy rin tayong magbabantay sa paglilitis ng punong mahistrado sa Senado at mag-uulat mula roon ang ating kasamang si Joseph Morong.
Dito man po sa studio kasama nating legal expert. Magbibigay po ng mas malalim na pagtingin sa proseso ng impeachment trial na Chief Justice Corona.
Ikinagagalak po nating makasama ngayong hapon si Dr. Antonio Lavinia, ang Dean po ng Ateneo School of Government ng Ateneo de Manila University. Good afternoon, sir.
Good afternoon po.
Magandang hapon po.
Ayan, bago tayo dumako sa impeachment trial, alamin muna natin ang latest. Naku, ito inaabangan po.
Ilan kaya pumasa?
Oo, sa Korte Suprema tayo at yung listahan na po ng mga pumasa sa 2011 bar exams.
1,913 examinees o 31.95% ang nakapasa sa pagsusulit na yan. Ang 2011 bar exams, ang pangalawang may pinakamataas na passing rate sa nakalipas na dekada. Para sa detalye, makibalita tayo kay Lia Manyalak del Castillo. Lia?
Yes, Cara, puno na nga ng kaba itong buong Supreme Court dahil sa pag-antabay ng mga kaanak, yung mismo mga nag-take ng bar exam, at yung mga kaibigan nila sa pag-aantay ng resulta ng 2011 bar exam. Ilang minuto na nga lang ay inaasahang ilalabas na yung listahan ng mga nakapasa. 1,913 o 1,913 nga yung bilang ng mga nakapasa sa 2011 bar exams o 31.95%. Iyan ang ikalawang pinakamataas na passing percentage simula noong taong 2002. At yan daw ay resulta nung naging mas in-improve na na exams, kasi ngayon hindi lang puro essay yung naging exam nila. Meron din silang multiple choice at dalawang type rin ng essay yung pinagawa. Yung isa, pinagawa sila ng trial memorandum, yung katulad ng inihahain sa mga korte, at yung isa naman, isang legal opinion na ibinibigay sa mga kliyente. So matatandaan, Cara at Igan, na September last year ginawa yung bar exams sa University of Santo Tomas sa halip na Nobyembre, katulad ng mga nakasanayan na mga nakaraang taon. At meron nang nakaset up dito na dalawang widescreen para makita agad ng mga bar passers yung kanilang mga pangalan, oras na ilabas na yung listahan. Inaasahan na mismo si Justice Abad ang maglalabas ng top 10 para sa nakaraang bar exams. Yung mga nakapasa ay mag-host taking sa March 21 sa PICC. Cara.
Alright. Maraming salamat, Lia Manyalak del Castillo.
Ayan, good luck doon sa mga nag-aabang ngayon doon. Nakita natin, kumain na kaya yung mga yun?
Oo nga. Sabi ni Lia, pinalitan pala yung exam ngayon. Multiple choice na. So, mas madali kaya yun?
Mas tumaas yung maraming pumpasa eh. Okay, punta na natin si Joseph Morong sa Senado. O Joseph, ang bola nasa depensa niya. Di ba? Ano pa inaasahan ng paglitis ngayong araw?
Not quite, Arnold, kasi meron pa tayong isang iko-cross. Itong si Danny, na cameraman. Iko-cross-examination lang yan ng depensa nitong si Justice Cuevas. Pero magiging maikli na yan. Ngayon, ang mangyayari ay, sandali muna, yung kay Enrile muna kanina na-ambush siya. Ang sabi niya, gusto niya sana na personal na tumistigo itong si Chief Justice Renato Corona dahil nga pagkakataon na ng depensa in the next coming days na sila naman yung magpipresenta ng kanilang mga ebidensya. Ayon dito kay SP Enrile, ay mas maganda na personal na marinig ang eksplanasyon mula kay Corona tungkol sa kung saan ba galing yung kanyang mga milyon o sa mga pera doon sa naibulgar na mga bank accounts. Pero bahala na raw si Corona kung titistigo siya dahil hindi siya pwedeng ipasabina ng Senate Impeachment Court dahil nga doon sa nauna nilang ruling na co-equal nila yung mga justices ng mga maestrado. Ayon kay Enrile, ay si Corona nga lamang makakasagot kung saan galing yung kanyang pera. Narito yung kanyang pahayag.
Sino ang makapagpaliwanag sa kanyang kung ginawa niya o hindi na ginawa, kung hindi yung mismong nakasakdal?
Igan Karan, ang sabi naman ng depensa ay willing daw o gusto raw nitong si Chief Justice Corona na humarap sa Senado pero umaasa pa rin daw ito na sa magiging abiso ng kanyang mga abogado. Sa ngayon, ayon kay Defense Counsel Attorney Judd Roy, ay wala pang dahilan para iharap si Corona sa Senado. Maaari naman raw na maipaliwanag nila ang mga bank accounts ni Corona nang hindi personal na pinapaharap si Corona. Pwede naman raw na ipaliwanag ni Corona ang kanyang yaman pero hindi niya ito sa Senado gagawin. Ngayon, ang inaasahan pag-uusapan natin ngayon ay yung cross-examination ng depensa lamang kay Danny Piedad, itong cameraman. Pagkatapos ito, ayon kay Congressman Miro Kimbo at si lead prosecutor Congressman Neil Tupas Jr., ay formal sila magmamanifest o magsasabi sa korte na ilalaglag na nila yung 5 articles of impeachment. Pagkatapos niyan, ay hihingi sila ng panahon para makapaghain ng kanilang formal offer of evidence. Pwede raw nilang gawin yung formal offer of evidence by tomorrow, Thursday, o kaya naman ay Biyernes. Pagkatapos ito, ang depensa naman ay hihingi rin ng panahon para naman sila ay makapag-object doon sa ihahain na ebidensya ng prosecution. Normally, ang sabi sa atin ay 15 araw ang gugugulin ng magkabilang partido para sa prosesong ito. Kara Igan.
So Joseph, ano mangyayari in the meantime na habang humihingi nga sila ng mga araw na palugit, magbe-break yung impeachment court? Ganun ba?
Pwede, ang sinabi nitong si SP Enrile kanina, no, ay pwede magkaroon tayo ng lull habang nangyayari yung formal offer of evidence ng prosecution. Pero hindi pa natin matitiyak yan kung ganyan yung magiging desisyon ng Senado ngayon. Pwede rin naman kasi na simultaneous, no? Halimbawa, habang naghihintay tayo doon sa written manifestation ng prosecution at yung kanilang formal offer of evidence, pwede nang sabihan ng Senate Impeachment Court yung depensa na simulan nyo na yung paglalabas ng inyong counter evidence. Ang sabi naman ng defense is that they're ready anytime para makapag-presenta ng kanilang mga ebidensya, Kara.
Okay, maraming salamat, Joseph Morong. Babalikan ka namin mamaya dyan. At tatalakayin naman natin ngayon kasama si Dean Antonio Lavinia itong yung pag-offer nung evidence. Kasi sinasabi ho ng depensa, Dean, makakapagbigay lang sila ng ebidensya pag yung offer of evidence. Pakipaliwanag po sa hindi kami mga abogado. Ayan. Ano yung i-offer muna ng prosecution ng mga ebidensya?
Bago nito, pwede bang batiin din yung aking mga students?
Ay, okay yun.
Good luck, naghihintay ng bar exams.
Sana pumasa sila lahat.
Papasa kayo lahat. So, good luck sa inyo lahat.
Ayan.
Pero balik sa tanong mo, ang ibig lang sabihin yan, formal offer. Kasi na-offer na, di ba? Binigay na ng mga... pinakita na ng prosecution, pinisent na nila yung witness, yung mga dokumento, minark na. Ngayon, isa-isahin ngayon ulit yan, sabihin, we are now formally offering, di ba?
Okay.
Yun yung official na ginagawa pag na-present mo na lahat ng evidence, kung tanggapin ba o hindi ng korte. Kasi sa ngayon, lahat yon pinayagan, pero hindi pa tinatanggap.
Okay.
Bawat ebidensya ngayon, pwedeng mag-object yung defense.
Paano yung may question ng source ng pagkakakuha ng mga ebidensya?
Well, may motion na nga yun, di ba? Yung sa PS Bank deposits, kahapon nata, nagano sila ng motion to suppress that evidence, no? Maaring desisyonan ng korte na tanggapin ito, kahit provisionally muna habang ini-imbestiga pa yung source niya, o maaari din sabihin na i-suppress na yung evidence. So, depende yan sa korte.
Pero in defense, gusto nila strike out. Ibig sabihin, wala sa record.
Strike out as if it was never presented.
So,
diba?
ibig sabihin, yung mga senator judges, kapag nag-decision sila, pag sinabing stricken out of the record yan, hindi nila pwedeng gamiting basihan yung mga na yun, na strike out kasi yon. Kahit na narinig nila.
Yes and no. Yes, in the sense na formally hindi nila pwedeng sabihin,
okay,
di ba? Pero no in the sense na hindi naman sila mga judges na magsusulat ng desisyon.
Hindi nila kailangan i-explain yung boto nila.
Hindi nila kailangan i-explain yung boto nila kasi political decision yun. Policy decision nila ng fitness ng Chief Justice, di ba? So tatanggapin nila lahat ng kanilang narinig, nakita, nababasa. Lahat yan pwede nilang gamitin na basihan ng kanilang desisyon. Kaya tungkol ito sa konsyensya, di ba?
Okay.
Konsyensya ng mga senador. Itong official process lang ay para lang dun sa ebidensya na officially pinisent. Pero sa tingin ko, pwede pa rin gamitin ng kahit anong kaalaman, anong facts na lumabas ng isang senador para basehan ng kanyang desisyon. Kaya maganda yung sinabi ni Senator Enrile na gusto niyang marinig mismo si Chief Justice, di ba? Kasi kahit anong sabihin mo, kasi kahit anong sabihin mo ng lahat ng mga napaliwanag, na lahat ng kapalpakan, sabihin na lang natin, no, ng prosecution, di ba? Marami silang pagkakamali, marami silang hindi na presenta ng mabuti. Sa kabuuhan pa rin, dun sa Article 2,
Meron pa rin dapat sagutin.
malinaw na may malaking gap between
Okay.
the SALN, yung sinabi ni Chief Justice Corona na kanyang pera at kanyang assets, dun sa mga lumabas.
Na
No?
pera niya.
Kahit na-suppress mo yung PS Banks, nandun pa yung BPI deposits,
Okay.
nandun pa yung mga binili ng mga kondo, lahat yun,
Okay.
di ba? Parang hindi nag-add up. So, kailangan i-explain yun. Kaya
Bakit
medyo
hindi niya
nadinis-
dineklara yung pa rin?
hindi dineklara, di ba? At kailangan i-explain bakit hindi niya dineklara, di ba? Nagkamali ba siya? Hindi ba nila pera yon? Hindi ba niya pera yon? Kasi pera pala yun ng, di ba sinasabi nila sa Basa Gidote yun na pera, kaya
Sa kumpanya ng
ganun, di ba?
kanyang
Kumpanya ng
misis.
misis niya.
Ng kumpanya ng misis niya.
Oo.
Kailangan natin marinig yon para masabi na talagang ang karapat-dapat na hindi niya dineklara o kung hindi niya dineklara na nagkamali lang siya, pwede rin yon, di ba? Kasi sinasabi naman ng SALN law na kung nagkamali ka, ayusin mo.
Kasi may sa record nung siya'y dinidinig pa sa Judicial and Bar Council, ang nagpetisyon dyan yung isa sa mga opisyal ng Gedote,
Yung
sinasabi
uncle ata niya.
Right.
yung
Oh,
uncle
meron
ni
siyang
Corona.
sinabi na hindi ako nakikialam sa kumpanya ng wife niya. Tapos paano niya ngayon uugnay yun na kung hindi ka nakikialam, bakit sa account mo dineposito yung pera ng kumpanya na yon? So sasagutin niya rin yun.
Kailangan niya sagutin.
Kaya
At sa
sagutin
tingin
niya
niyo po, at sa tingin niyo po din, siya lang ang makakasagot nito
Siya
mga
lang.
to.
Walang iba eh.
Hindi
Kasi-
pwedeng documentary evidence or
Hindi, kasi kung may document, kailangan merong mag-introduce ng document, di ba?
Right.
Siya lang mismo makakapag paliwanag kung saan nga ba nanggaling yung pera na ito, di ba, bakit winidraw nila.
Pero
Yung
hindi naman kailangan personal din siya umaten, di ba? May ganun ding ano Mas maganda kung siya magpapaliwanag, pero may option din siya na hindi niya kailangan dumalo sa impeachment trial.
paano niya mapapaliwanag kung hindi siya?
Nandun yung mga defense niya, lawyer niya.
Hindi. Kasi wala namang hearsay yung defense lawyers.
Okay.
Babalik ngayon yung sinasabi ng defense
Ng hearsay.
lawyers. No? Di ba na hearsay
So
yun.
kailangan siya
Kung
mismo doon sa witness
Siya
stand.
mismo sa tingin
hindi
ko.
pwedeng written.
Sa tingin ko, kahit na yung mga judges na maaring in favor sa kanya,
Oo.
o nagbibigay ng certainly ng presumption of innocence sa kanya, gustong marinig yun. Kasi kailangan maribat yung ano na yun.
Kasi may una na siya mga sinagot doon sa articles of impeachment Pero wala doon yung mga PS Bank deposits
yung
niya.
yung BPI,
Right.
hindi niya sinagot
Sinagot na niya
yung
dati yung dati. Oo.
Hindi niya, kasi ang sinasagot lang niya sa kanyang answer, ay meron siyang SALN, hindi lang publicly na-disclose dahil sa
Okay.
Supreme Court decision. Yun na naman
Pero din, kung kunyari, matanggal nga sa record, kunyari, mag-decide ang senator judges na fruit of the poisonous tree at gusto nilang at hindi dapat bonlat-latin buksan itong mga PS Bank records, kung i-strike off the record yung mga evidence na yan, kailangan pa bang humarap ni Chief
Oo,
Justice
kasi
Corona?
hindi pa rin mag-add up yung BPI, yung mga biniling mga kondo, hindi pa rin yung mag-add up sa amount na sinasabi niya na meron siya at assets na sinasabi niya dun sa kanyang SALN.
Mawala man sa record, hindi man nawala sa isip ng publiko
Oo.
Yung mga
At ng
nanonood
Senator Judges.
At ng Senator Judges, di ba?
Kaya kahapon yung iba nagulat na winidraw yung lahat ng articles, di ba?
Nagulat din ako doon.
Oo, pero yung iba sinasabi, ang kausap dito ng mga prosecution, publiko. Di ba? Dahil kung kahit na hindi nila ituloy ibang artikulo, doon nga sa tinatawag na Article 2, hanggang ngayon nakabitin pa tayo at naghihintay ng paliwanag doon sa respondent. Di ba, Tin? Kaya magandang move nga nila yun para mapabilis na rin ito.
Oh, well, kasi parang ang lumalabas din na nawawalan na ng interest yung publiko, di ba? Na kasi kung i-pursue nila yung ibang articles, kung ganito kahaba pag-pursue nila ng pagbibigay nilang ebidensya, abot tayo ng 3-4 na buwan. Pas sila lang yun.
Nawawalan na yata sila ng witness. Camera man nga lang, pinapatawag na.
Nawawalan ng witness. Pero nagulat pa rin ako.
Nagulat din kayo.
Nagulat pa rin ako kasi
Sabi nila
siyempre,
matibay di ba?
mataas din yung expectations mo. No? Sinabi nila 100 witnesses sila, mapoprove nila ito lahat, di ba? So para bang yung isang natatalo yung prosecution dito sa game of expectations.
Yes, oo.
Kasi akala ng mga tao na ang galing-galing ng kaso sa simula, di ba? Sa tingin ko, pag magpa-polling ka ngayon, mas marami na nagsasabi na hindi sila sigurado kung dapat i-convict pa si Corona o hindi, di ba?
Okay.
Dahil ang lakas ng dating sa una parang, tsak talaga tayo dito. Suddenly ngayon, back to 3 articles, probably only 1 article Sa tingin ko, ang malakas na talaga Article 2. A little bit
SAL-N.
stronger yung SAL-N.
Okay.
Yung a little bit sa Article 7 dahil nandun yung dissent ni Justice Sereno. Pero yung Article 3 medyo malabo
yun. Isa na nga lang yun, yung pass-up lang eh. Okay, Dean, teka lang ha. Balikan ka namin mamaya. Yan po si Dean Navinia. At nagsisimula na po impeachment proceedings. Panoorin na po natin.
12 Journal of the Senate sitting as an impeachment court is hereby approved. Please call the case, Madam Clerk of Court.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances. Majority Floor Leader.
For the prosecution, Mr. President.
Good afternoon, Your Honors. For the prosecution panel of the House of Representatives, same appearance, and we are ready, Your Honors.
For the defense.
Noted. Defense.
For the defense, Your Honor, the same appearance. We are ready also.
Noted.
Mr. President.
Majority Floor Leader.
Yes, Mr. President, thank you. Before the business of the day, yesterday, the Minority Leader was asking for the floor. So may we recognize the Minority Leader, Senator Alan Cayetano, Mr. President.
The gentleman from Taguig.
Magandang hapon, Mr. President.
The Minority Floor Leader.
Sir President, yesterday when Congressman Nery Colmenares brought up certain topics, I asked to be recognized today because I did some research dwelling on the immunities of Supreme Court justices because of this Inre Raul Gonzalez, which practically states that a member of the Philippine Bar, that it is a qualification to become a justice, that you have to be a member of the Philippine Bar. And you cannot file a disbarment case during the incumbency of a justice, nor can you file a criminal case before the Sandigan Bayan of any offense which carries with it the removal from office, meaning the only way to address issues of transparency and accountability to justices is through an impeachment court. The President only has a immunity from suit for his term of 6 years, but since the justices retire at the age of 70 years old, they basically have a much longer time of immunity in effect, no? Because of what some people term procedural immunity. And I see the point of this. You cannot see a situation wherein a Supreme Court justice is being tried before the Sandigan Bayan, and then the appeal will be before the Supreme Court. And at the same time, they passed a resolution, and to be fair to this Supreme Court, it was the previous members that basically made it very difficult, if not almost impossible, for anyone to get a copy of the SAL-N. No? And so, basically, Mr. President, ang sinasabi ko po, with all of these immunities, ang takbuhan lang ng tao po yung impeachment court. Pero kung ang magiging desisyon po ng Supreme Court is that every step of the way, whether pagsusupina ng kanilang records, ng mga tao, etc., ay hindi pwedeng kunin, lalong nasa-strengthen yung kanilang so-called immunity. So, saan katatakbo? Parang may problema tayo, which came first, the chicken or the egg, no? Kukunin mo ba yung ebidensya at kakasuhan mo ba muna siya bago ka dumating ng impeachment? Or pag nasa impeachment na, sasabihin na saan ang ebidensya, magiging technical tayo, and hindi mo naman pwede silang kunin na witness, hindi mo pwedeng kunin yung records. Samantalang malinaw naman sa lahat ng court rulings abroad na ang judicial misconduct is one of the exceptions to opening up their records, no? Regardless if the case is pending before them or not. The Nery case, which dealt with executive privilege, very, very clear yung umpisa niyang statement. Executive privilege cannot be used to excuse a crime. So I wanted to go into a discussion, Mr. President, an academic discussion rather than a ruling on the points that we have already ruled upon, because of my concern that whatever we do here will set a precedent. No, magiging basihan to ng future impeachments. I hope we will never have to go through this again with any of the other justices. I do know that tama po si Senator Miriam, let's talk about the country, let's talk about the future. Napakahalaga na yung integrity ng Supreme Court intact. Pero Mr. President, yun din po ang sinabi kasi natin sa militar nung sinabi natin wag imbestigahan, sinasabi lang wag imbestigahan si General Garcia, wag pag-usapan ang pabaon, wag pag-usapan ang mga nangyayari. But this actually strengthened the military, and the reforms that came afterwards actually strengthened the military. So I think there are good intentions in asking the Supreme Court to release some of their records or to make themselves subject to this impeachment court. Let me just put on the record, Mr. President, that some of the confusion is because of the name. Ang tawag po kasi natin ay Supreme Court. If we put the name Supreme Impeachment Court, magkakaroon ng context ng konti. Kasi lahat po ng justices, whether collectively or individually, is subject to the impeachment court because they are impeachable officers. Hindi natin pwedeng sabihin na pantay natin sila sapagkat lahat ng dapat magsasubmit sa jurisdiction ng court ay mas mababa sa korte. But, Mr. President, this will go into a discussion of the difference between dealing with the Supreme Court itself and members of the Supreme Court. So be that as it may, Mr. President, I was overtaken by some events and I think we agreed to talk about this in caucus instead. I know it is a very sensitive issue, but let me just reserve some time after our caucus or at the appropriate time, Mr. President, to talk about how the impeachment court can balance these two very important interests. One, which is the respect of a co-equal branch of the Senate, which is the judiciary, not a co-equal branch of the impeachment court. Number two, Mr. President, is the integrity of the adjudicatory process of the Supreme Court, its record, its people, how to ensure that ang justices natin ay protektado at hindi sila yung yuyugyog o sila ang kinakasuhan or yung independence ng judiciary. Napaka-importante yon. But at the same time, we know that absolute power corrupts absolutely. And alam po natin that there can be no person or no branch of government that can have absolute immunity. So, Mr. President, I just wanted to put this on record, and I prepared a legal study and some cases that we researched. But let me stop here, Mr. President, and discuss it in the caucus, and then maybe at the appropriate time we can have a discussion just for the records, as I said, because this will be a precedent, and it will be very, very difficult to impeach a erring Supreme Court justice if these issues aren't resolved. Thank you very much for this time, Mr. President.
Thank you.
Mr. President, Senator Pia Cayetano is seeking to be recognized, and while she is preparing for that, may I just call the attention of the Clerk of Court to page 54 of the journal, wherein the last line is acknowledged to the Senate President or the presiding officer, but this is Senator Drilon, just to make the proper correction. Typographical error, most probably. Anyway, for the record. So, Senator Pia Cayetano, Mr. President.
Thank you, Mr.
Gentle lady from Taguig.
Thank you, Mr. President. Mr. President, on Monday, February 27, the prosecution offered as evidence the testimony of one of their witnesses, Edmond Yasala. And in the journal of said date, it states, among many others, the purpose of why his testimony was offered. I will quote, "To prove that Respondent Corona, using his administrative powers as the Supreme Court Chief Justice, extended office hours so that the TRO condition can be fulfilled by GMA, and thus allowed GMA and then First Gentleman to leave." I was very interested in this allegation and was looking forward to the presentation of evidence on this matter, Mr. President. But let me move forward. Yesterday, Senator Lawrence stood up and she asked for clarification because she did not recall that there was any testimony given by any witness as to prove that, in fact, the office hours were extended. So I was intently listening to the query and to the response given to Senator Legarda. I refer to page 37 of our journal, wherein the statement, or should I say, the testimony of the prosecution, I refer to Attorney Pareño, refers to certain times. There was 1:30, 3 o'clock, and 4:30. Mr. President, I would like to put on record that the statements of counsel on the time that certain activities were taken, certain activities took place, have absolutely no bearing on this impeachment court. It will be recalled that it was counsel who testified on those times, and I would like to know if counsel has now offered himself as the witness. Has counsel taken an oath, perhaps when I stood out for a few minutes I just don't want people, whether non-lawyers or the millions of Filipinos who are watching, to be confused because there was no evidence that I can see in the record and that I have witnessed with my own eyes on the witness stand. Having said that, Mr. President, I refer back to the query of Senator Lauren Legarda, and in fact, page 37 of the journal will bear out her concern that the only reference to time provided by counsel, not by the witness, if I may emphasize again, was 1:30, 2:30, 3 o'clock, and 4:30 p.m. Mr. President, I mention this because I belabor this point because they used our time. We spent so many minutes trying not to fall asleep watching that video. So if there is no testimony that will accompany that video, can we please be more conscious of this? Or if the one who will testify on the video will be the lawyer, then please take the witness stand so that we do not waste the time of counsel, our researchers, our people, in trying to understand what is evidence that we must use in deciding this case. This becomes even more relevant because the prosecution has rested. So I leave this point, Mr. President. I don't require a response, but if the prosecution cares to respond, I am more than happy. Thank you.
The chair would like to state for the record that these statements, personal statements of the lawyers representing either side of the adversarial proceeding are not evidence. They are just a plain statement, manifestation, and they will not be taken into account as proof of anything except that they said it. Anybody who wants to respond to the lady senator from Taguig? From the prosecution side.
Your Honor,
pwede na kayo humarap dito sa Korte Suprema. Kung gusto mag-volunteer, additional defense counsel, pwede na rin kayo. Nagagalak ako ngayong hapon ito. Alam ko, masaya-masaya tayong lahat kasi ito ay siguro isa na sa pinaka-importanting reforma na ginawa natin dito sa bar examination. Alam naman ninyo, more than 100 years yung format natin ng bar at ngayon lang tayo naglakas loob mag-overhaul ng ating sistema ng conduct ng bar examination. Kaya kayo po, in a way, parang kayo ang naging experimental class na ito. Sapagkat mukhang hindi naman kami nagkamali sa mga reforma naming inisip para dito sa bar exam. Kasi ang aming kinakabanong umpisa, baka masyadong mahirapan dahil bago nga yung sistema. Ang pinangangamba namin ay baka masyadong marami ang bumagsak. Pero on the contrary, hindi po lalong tumaas po nga yung passing average. Ito na lang po masasabi ko. Wala naman tayong pero except as we go along, siguro beginning next year o 2 year nang ito, we will continue to refine the bar examinations and introduce as many more new innovations for the bar examination. Ang purpose naman po nitong bar hindi para ibagsak kayo, kundi malaman kung ano ang minimum standard na kailangan tanggapin natin ang pagbabatayan natin ng inyong pagiging abogado. Isa pong masasabi ko lang dito, alam po ninyo, ang success ninyo bilang abogado ay hindi lamang dependent dito sa bar examination. Siguro hindi naman kaila sa inyo ang istorya ng isang pinakatanyag na abogado dito sa Pilipinas, si dating Senador Claro M. Recto. Noong una siyang kumuha ng bar examination, ang balita ko ay hindi yata siya pumasa. Ngunit nung kumuha siya ng pangalawang beses, naging bar top na chair. At lalo-lalo na, after that, siya ay naging isa sa pinakatanyag na abogado dito sa Pilipinas. Kaya wag po kayong mawawala ng loob kung kayo mo medyo hindi pumasa ngayon o kaya medyo hindi masyado mataas ang nakuha natin, hindi naman yan ang pagbabatayan ng inyong success as a lawyer. Ultimately, kayo po ay dependent na po sa sarili ninyo. Sariling pagod, sariling sikap, sariling commitment po na mag-aral and to continuously find more knowledge and look for additional skills para kayo ay maging magaling na abogado. So, yun lang po masasabi sa inyo sa dun po sa atin na successful at sinwerte. My heartfelt congratulations to you. Yun naman po sa medyo kinapos ng konti ng average. There's always a next time. Huwag kayong mawawala ng pag-asa. Gusto ko pong ipakilala sa inyo ang naging chairman ng 2011 bar examinations. Isa po sa pinakamagaling, pinakamatalino, at pinakamatalas na justices ng Supreme Court, dating Dean ng UST College of Law, Justice Robert Abad.
Salamat sa inyo. Gusto nyo na bang ilabas natin ang resulta o bukas na kaya? Out of 6,000 candidates, ang pumasa ay mga parang 1/3, 1,913 or 31.95%. Okay. For the first time, itong multiple choice ay aming pinalabas. Ang pumasa sa multiple choice ay 34% sa multiple choice. Ngayon, sa essay, doon ang medyo dalawang essay natin, legal opinion at saka memorandum, trial memorandum. Sa legal opinion, 50% na pumasa. Sa trial memorandum, 15%, 15%. Kaya yun ang medyo nakahila ng konti. Hindi naman masyadong sobrang hila, konti lang. Okay, i-announce ko lang na ang inyong oath-taking sa mga papasa ay sa March 21 sa PICC. Tapos, kukuha kayo ng clearances sa Office of the Bar Confidant from Monday to Friday. Magdala kayo ng ID nyo at from March 1 to March 23. Okay. Let me see. Okay. I-announce ko na siguro na ang mga top-notchers. First place, si Raul Angelo Atadero from Ateneo de Manila University. Second place, Luz Daniel O. Bolong, Ateneo de Manila University. Third place, Cherry Liz Rafael Roble, Arellano University. Fourth place, Rosemil R. Banyaga, Notre Dame University from Cotabato City. Fifth place, Christian Louis Gonzalez, University of Santo Tomas. Sixth place, Ivan M. Bandal, Siliman University. Seventh place, Erin Sina M. Acosta, San Beda College. Eighth place, Irene Marie Cuwa, Ateneo de Manila University. Ninth place, Elaine Marie G. Laceda, Far Eastern University, DLSU. And 10th place, Rodolfo Aquino, San Beda College. Okay? By virtue of the resolution of the Supreme Court signed yesterday, we are now ordering the release of the grades. Thank you very much.
Ayan po, nilalabas na po yung resulta ng 2011 bar exams at naku, siguro kakandahaba liig ng mga...
Oo, ulitin lang natin, Arnold, yung kanina sinabi yung top 10. Yung 1 at saka 2 ay galing sa Ateneo de Manila University. Number 3, Arellano University. Number 4, galing sa Cotabato, Notre Dame University.
Wow.
Number 5, alma mater mo, UST.
Ghost
Number 6, Silliman University. 7, San Beda University. Number 8, Ateneo de Manila University. Number 9, FEU. At number 10, San Beda.
At siguro maraming nagulat dahil humarap mismo sa kanila si Supreme Court Chief Justice Renato Corona.
Ito daw yung first time na humarap siya sa...
Ang punong maestrado. Tawagin natin si Lia Manialac. Lia, kamusta ang dyan? Fiesta mood ba?
Igan, hindi pa masyadong fiesta mood kasi yung iba hindi pa nakikita yung kanilang pangalan.
Ako rin hindi makita.
Pero kanina natuwas yung karamihan dito nung lumabas si Chief Justice Corona para i-address yung mga nag-aabang sa bar exam results. Samantala, banggitin ko lang ulit yung top 10. Ang number 1 ay si Raul Atadero ng Ateneo de Manila University. Taga-Ateneo rin ang number 2, si Luz Daniel Bolong. Taga-Arellano University ang ikatlo, si Cherry Rafael Robles. Number 4, si Rosemil Banyaga ng Notre Dame University. Number 5, si Kristen Louis Gonzalez ng UST. Number 6, si Ivan Bandal ng Silliman University. Number 7, Irene Acosta, San Beda College. Number 8, Irene Cua naman ng Ateneo de Manila University. Number 9, Elaine Laceda ng FEU. At number 10, si Rodolfo Aquino ng San Beda. 1,913 nga, Igan at Kara, yung nakapasa sa bar exams ngayon. marami rito yung nag-aabang, yung ilan, mga second takers na at excited na makita yung kanilang pangalan. Igan?
Okay, maraming salamat, Leah Manyalak.
Okay. At congratulations kay Dean Lavina.
Dean,
estudyante niyo daw yung number 2, yung top 2.
Oh, congratulations. Pero malungkot si Dean. Mamaya pag-usapan natin. Okay, yan po
yung UP loss, ano yung UP loss doon, di ba? Pero importante yung passing mark, yung passing percentage. Yan naman sinasabi namin palagi kahit sa anong school, mas mahalaga yung passing percentage.
Okay, yan po pinakahuling pangyayari sa Korte Suprema kung saan inilabas nga po itong resulta ng 2011 bar exam.
Ang top notcher ay galing sa Ateneo de Manila University, si Raul Angelo Atadero. Bago nito ay humarap sa mga nag-aabang sa resulta ng bar exam si Chief Justice Renato Corona at nagbigay ng maikling mensahe. Samantala, balikan natin ngayon ang impeachment trial sa Senado.
Mr. President, as manifested during yesterday's trial, the prosecution will no longer present evidence with respect to Articles 1, 8, 4, 5, and 6 of the verified complaint for impeachment, but reserves its right to present evidence on the dollar accounts of Chief Justice Corona.
Only on Article 2.
Yes, may we now call on the prosecution? May we know the pleasure, Mr. President? Oh, yeah, before we do that, I'm sorry. I withdraw that request, Mr. President, and ask that Senator Miriam Defensor Santiago be recognized.
The gentle lady from Iloilo.
Mr. President, yesterday you were struck by a thunderbolt. All of a sudden, the prosecution stood up and said, we have 8 articles of impeachment, but we are no longer presenting or withdrawing at least 5 of those articles, leaving us with only 3 articles of impeachment. In my entire career as an RTC judge of Quezon City, I have never seen a lawyer in a civil case, which is in this instance parallel to an impeachment trial, withdraw any cause of action that he told the court he would present evidence on. That has never been done. An impeachment trial is like a civil trial and like a criminal trial. An RTC judge's jurisdiction over all kinds of trials, civil, criminal, and special proceedings. I have never heard, apart from my own individual experience, I've never heard of a civil case where there are several causes of action, where the lawyer suddenly says to the judge, I'm sorry, Your Honor, made a mistake. I now want to withdraw or drop more than half of my causes of action. This is unprecedented. That is why I feel obliged as Senator Judge to enter into the record my very serious concern about this development. Number 1, Counsel, you please take a seat. Number 1, early in this trial, I asked both panels, to please tell the court how many witnesses you will present and how many pieces of evidence you expect to authenticate by the testimony of your respective witnesses. Both panels submitted their so-called compliance. That is to say, when a judge issues an order and you comply with the order, you file a piece of paper called compliance, and then you attach whatever it is that the court wanted to see or hear or to read. There's a compliance dated 27 January 2012, filed by the House of Representatives, where the order of the court was, list down all your testimonial and documentary evidence on my instigation. And I have this copy of the compliance by the House of Representatives. Number 1, Article 1, partiality to Mrs. Arroyo in Supreme Court decisions. Testimonial evidence, 6 witnesses. Documentary evidence as appropriate. This is a long list of documents that 6 witnesses were supposed to authenticate. Article 4, irregularities in the issuance of the status quo ante order on the impeachment proceedings of former Ombudsman Merceditas Gutierrez. Testimonial evidence, said the prosecution panel, 7 witnesses, plus the corresponding list of documentary evidence to be presented through those 7 witnesses. Article 5, gerrymandering in the creation of 16 new cities and the declaration of Dinagat Island as a province. Testimonial evidence, 3 witnesses. I'm quoting the prosecution panel. Documentary evidence, a list of cases. Article 6, allegedly improper investigation of Associate Justice Mariano del Castillo's plagiarism case. Testimonial evidence, 2 witnesses. Documentary evidence, as listed. Article 8, failure and refusal to account for the Judiciary Development Fund and special allowance for the judiciary. Testimonial evidence, 7 witnesses. All these witnesses are listed here, what their names are, what their addresses are, and what is the purpose of their proposed testimony. Plus, of course, the documentary evidence to be authenticated by these witnesses. So, House of Representatives, January, tells us in the impeachment court, we'll present these witnesses, we will also prove and authenticate, introduce into evidence and authenticate documentary evidence. Now, all of a sudden, it's only March, January, February, March, all of a sudden, there's a complete turnaround. Ni hi, ni ho, wala. Basta sabihin lang niya, ayaw na namin na presenta ng ebidensya. Ngayon, this is of very serious concern to me as a lawyer and as a former judge. Una, naglalaro ba? Nagbibiro ba kayo? In writing ang inyong compliance nga. Sabi niyo, we'll present so many witnesses, so many documentary pieces of evidence. Pagkatapos ngayon, sabihin niyo, without explanation, our case is very strong. We no longer want to present evidence on these causes of action. You are prejudging the case. What are you? What are you doing? Conducting trial by publicity? Let me remind you, an impeachment trial is both quasi-judicial and quasi-political. But let me place this in context. In its quasi-political aspect, an impeachment trial is not to be decided by the reading public or the viewing public or by any of the publics that we are addressing. It is true that the Constitution provides sovereignty resides in the people and all government authority emanates from them. But sovereignty resides in the people is a term of art in law, meaning to say it is a special code. It has a special meaning. It's not being used in its ordinary meaning. When the Constitution says sovereignty resides in the people, what people are we talking about? All 98 million Filipinos? Or all 65 million registered voters? A majority of registered voters? All survey firms? Or which survey firms are you referring to? Referenda? By certain NGOs? Referenda and surveys in certain campuses? No. This is not a direct democracy and we are not in Athens. The people are not going to decide this case. It is the Supreme Court and it is the High Court of Impeachment, this Senate, and the Senate alone that will decide this case. We are going to hold ourselves immaculate of all the propaganda that you are distributing abroad, meaning to say outside of this courtroom. Mapropagandaize kayo sa gusto ninyo. Walang epekto yan. Ngayon, hindi naman ito, as I said, hindi ito direct democracy. Representative democracy ito. We, the impeachment court, are the representatives of the people. We have been chosen by the Constitution to exercise the sovereign powers of the sovereign people in making a decision on the impeachment trial. Kaya galang naman ninyo kami. When I heard this news yesterday, I felt like creeping back into bed and adopting a fetal position, which is the normal reaction of any sane person when he is faced with a world that is crumbling around him. I no longer know what universe I am in, because I've spent 5 years of my miserable adult life in trial court day after day after day, hearing civil, criminal cases, and special proceedings. But I've never seen this done to a judge before. Ngayon, first point of concern was the compliance of the House of Representatives telling us that they were going to present such witnesses and such documents under these articles, but now they're being withdrawn or being dropped. At the outset, my request is prosecution files the written motion as directed by the Senate President. Will you please verify, are you withdrawing the articles or are you just waiving the right to present evidence on them? There's a difference. If you're withdrawing the articles, then you have to amend your complaint, because under the rules of court, you have to amend your complaint to conform to the presentation of evidence. Di pala kayo mag-ebidensya, ba't nyo lilistan yan? On the other hand, if you're completely just waiving the right to present evidence, then you give the defense the right to present evidence even if you have already waived your own right. Just because you waived your own right does not mean you can waive it for the other side. You've already, in effect, raised suspicions in the mind of a reasonable person about the moral position of the Chief Justice. Of course, they have a right to present evidence to dispel those suspicions raised by your own complaint. Kaya, pakiliwanag lang. Kayo ba ay sinasabi nyo sa amin, ayaw na namin itong articles of impeachment at baliwala na, pakibasura na. O, nandiyan pa rin yan sa aming complaint, pero ayaw namin magbigay ng ebidensya. Will you please make a distinction between those two? Because each of those optionals have their own peculiar circumstances in law. Ngayon, nagbasa na ako ng mga sinabi ninyo noong Enero lamang. Para so pala ngayon, nagkapalit na kayo ng isip. I am very, very concerned that this might constitute unethical behavior. In trial court, we have also a term of art called, which sometimes used, and it is normally runs to frivolous and sham. Frivolous and sham is not to be taken its ordinary meaning. It is also to be taken its technical meaning. And this is a technical meaning of a frivolous claim. A frivolous claim in legal terms refers to a lawsuit or motion in lawsuit motivated by an intent merely to harass, to delay, or to embarrass the opposition. In order to be found frivolous, the claim must have no arguable basis in law or in fact. Ngayon, let me remind you, prosecutors of the prosecution panel, of your code of professional responsibility, kung abogado kayo, Canon 10, a lawyer owes candor, fairness, and good faith to the court. Nang sinabi niyo sa compliance niyo, napipresenta kayo ng ebidensya at bawat testigo ay maglalabas ng mga dokumento niya. Were you in good faith? Because now you turn around and say you don't want to do that. Canon 10, a lawyer owes candor, fairness, and good faith to the court. Rule 10.01, a lawyer should not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. You've been misleading the court. There are some senator judges who, as a matter of personal discipline, read well ahead of the two panels. So if you present a complaint with us for impeachment with 8 articles, there are some lawyers among us who will read for all 8 articles. That's what the law calls frivolous. When you later say, I don't want to present evidence on 8, I only want to present evidence on 5. Plus, let me remind you, gentlemen, the lawyer's oath. I will do no falsehood, nor consent to the doing of any in court. I will not, wittingly or unwillingly, promote or sue any groundless, false, or unlawful suit, nor give aid or consent to the same. Cases. Prieto v. Corpus, 2006. No person should be penalized for exercising the right to litigate. This right, however, must be exercised in good faith. Must be exercised in good faith. I am very concerned that the prosecution has been in bad faith all along. Kung ano nung mga pinagsasabi niyo sa media, ba't hindi kayo mag-official manifestation dito? Manalo na kami. Meron na kaming proof beyond reasonable doubt. Good grief. That is contempt of court. It's already staring us in the face and it's about to bite our nose. And you expect me to be part of a court that just says nothing about it? You are engaging, gentlemen, in a public discourse on the merits of your case. You're not supposed to say that at all. Ang yayabang ng mga nagsasalita na ganyan, ang gago naman. Ay, my goodness. Ang kakaguhan is a ground for contempt of court. Another case, Philippine-British Company, V. de Los Angeles, 1975. By failing to substantiate his serious charges when called upon to do so, a lawyer may not only show his dubious motive, therefore, but the falsity of the charges as well, which merits disciplinary action against him. Eh, pero yung tatandaan ninyo eh. Nilista kayo sa amin, nakarobe kami at lahat. We look like a convention of undertakers every day. Coming here in these robes, you're supposed to grant us full and high respect. You cannot give us a list and then after a few months say, oh, I'm sorry, but I've decided to change this list. You can't do that to a court that you respect. Again, the Code of Personal Responsibility, Canon 12, a lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. Case, Pepsi Cola Products v. Court of Appeals 1998. As officers of the court, lawyers have a responsibility to assist in the proper administration of justice. Hindi ito politika, gentlemen. We are not in politics where you are free to hire character assassins and do all manner of dirty tricks. This is a quasi-judicial proceeding. Itigil na ninyo yan. Yun ang problema nyo eh. Mahilig kayo sa ganyan eh. You're very fond of the occult arts. As officers of the court, lawyers have a responsibility to assist the proper administration of justice. They do not discharge their duty by filing pointless petitions that only add to the workload of the judiciary, especially this court, which is burdened enough as it is. A judicial study of the fact and the law should advise them in a case such as this should not be permitted to be filed to merely clutter the already congested judicial dockets. They do not advance the cause of the law or their client by commencing litigations that, for sheer lack of merit, do not deserve the attention of the court. That was the Supreme Court speaking in all those cases. Were you aware of these decided cases when you decided on your own to make that manifestation yesterday? That was my second point. The first point is, you filed a compliance and you listed, according to the instruction of this court, your list of witnesses and documentary evidence for every article. And now you turn around and say, oh no, we've changed our mind. That can be a very expensive change of mind. Second point of concern, that might be an ethical behavior. I have never seen such a parody of justice in my entire adult life in the judiciary. I remind you, for those of you who have been talking to your character assassins, I've been awarded as a judicial judge for excellence in trial work, not only by the TOYM of the JCs, the TOWNS of the Lions, but many other NGOs, whom I will no longer enumerate. Kaya siguro may alam akong konti tungkol sa batas. Huwag nyo kaming ginaganyan-ganyan. Last and most important, I will not be able to help it if the members of the impeachment court will engage in the judicial and legal presumption that evidence willfully suppressed would be adverse if produced. Kayo mismo ang nagdala nito ah. You called up this disputable presumption when the defendant refused to give his consent to the opening of his dollar accounts. You said evidence adverse, evidence suppressed is evidence adverse. Kung ayaw mo ipresentang ebidensya, ibig sabihin, kung walang ebidensya pang dagdag, na may tinatago ka. Yun ang sabi nyo sa Chief Justice. Ngayon naman ang ginagawa nyo. Sinabi nyo na 8 articles of impeachment nyo. Ngayon ayaw na nyo maglabas ng ebidensya nyo sa 5 of those 8 articles. Then let me invoke the disputable presumption against you. The rules of court provide disputable presumptions. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. Letter E, that evidence willfully suppressed would be adverse if produced. Ngayon, ano kayang ibig sabihin ng teknikalidad na yan? In People v. Padrigona, 2002 case decided by the Supreme Court, the court said, this rule that evidence willfully suppressed would be adverse if produced does not apply if A, the evidence is at the disposal of both parties. Yung ebidensya ba ninyong nilista ninyo sa compliance ninyo ay pwede nyong ibigay doon sa defense? That is the only exception. Another exception, the suppression was not willful. Willful ito eh, kasi kusa nyong ayaw nyo eh. Wala namang supervening factor that prevents you from presenting your evidence that you already said to us in January you were going to present. Letter C, this merely corroborative or cumulative. This does not apply because when you file an impeachment complaint, you have different articles of impeachment which are separate from and independent of each other. So none of these articles of impeachment, just like causes of action in a civil case, are said to be cumulative or corroborative. Cumulative means you already produced evidence in the form of one witness and you just want to add, let's say, 10 more witnesses to completely repeat what that other witness said. That is corroborative. Kaya, kung corroborative lang witness mo, pwedeng hindi mo na ipresenta. Ito naman, hindi corroborative eh. Because they are separate and distinct articles of impeachment. And letter D, the suppression is an exercise of a privilege. Kaya yung defendant sa bank accounts niya, ayaw niyang magbigay ng consent niya. But we cannot apply this presumption to him because the suppression is the exercise of his privilege. That is a privilege given to any person who opens a dollar bank account. The law provides confidentiality is absolute except only when the depositor is giving his consent. Ngayon ito, kaiba itong inyong kaso na ito. Wala kayong privilege eh. When you file an article of impeachment or a cause of action, it is not only your right to present evidence, it is also your duty. It's not a privilege that you can just waive at will. That is not what the law means by the suppression is the exercise of a privilege. You have no such privilege to bother the court. Cases. People v. Melo Santos, 1995. The prosecution evidence must at all times be competent and admissible to sustain its stand. The prosecution cannot rely on an imaginary person charging a serious offense without extending to the accused the benefit of confronting his accuser. In default of a satisfactory premise for the non-presentation of a crucial witness, it ineluctably follows that disputable presumption that evidence deliberately withheld would be adverse if produced remains undisturbed. May tatago kayo. Takot ba kayo? Kayo ang sinasabi nyo, panalo na kami dito sa tatlo. Kami ang magdesisyon yan, hindi kayo. Ang yayabang nyo. Maaga pa. What are you, conducting trial by publicity? Is that what you're trying to do? We will not be swayed. The entire capacity for tsunami waves by Manila Bay can fall over this impeachment court and will not be affected by what you say in the public or what your chosen public brings back to you, particularly if they've been paid to do so. Please, do not try these little dirty tricks on us. We're all old people here. Tumanda na tayo lahat sa politika, huwag nyo kaming ginaganyan, ha? Kamukha ng survey, just as I predicted. Aba, may balita kanina sa isang dyaryo. Nang survey daw sa UP, 500 ang respondents at like 75% of them said, no, we no longer trust the Chief Justice. Kayo mga UP kayo, dapat kayo i-kick out immediately. If you are true, actual persons, you should be kicked out immediately. Because you do not deserve to be in UP, and the people who machinated the publication of that press release should likewise be kicked out of UP. If they're enrolled in the rolls of the university as alumni, they should be permanently erased from the rolls as a perpetual shame on the university. Pero mo, may survey daw sila na 500 katao sa UP nagsabi ng Chief Justice so far because of the prosecution evidence can no longer be trusted. Ang taas pa naman ang pagtingin ng tao sa UP, pagkatapos 500 lang out of, let us say, 50 million all over the Philippines, and it's not even conducted on scientific basis. It's not conducted by any of those reliable survey firms that have already been proven in their forecast for election results. Kanya-kanya lang sila. Grabe. My goodness me. If I were the symbol of UP standing there, naked, called the oblation, I would immediately throw away my fig leaf. Huwag na tayo magtago-tago pa. Kagaguhan lang naman pala ang pinapag-aralan sa UP kung ganyan. I cannot imagine a survey where 500 high IQ people will say, we have already lost trust in the Chief Justice because we have already heard the evidence from the prosecution, although we admit that the defense has not yet presented its case. Grabe naman. Sino namang PR firm nag-isip nito? Sabihin lang ninyo, hanapin ko yon. You are playing games. I was not born yesterday. I was born a long time ago and I'm about to die. I want to leave a legacy that at least when presented with this anomaly in trial technique, I rose to condemn it. We will be studied generation from now by other senators faced with other impeachment cases, And I do not want the records to reveal that we allowed this development to pass by uncommented on. This is a travesty. Una sabi nyo, malakas ang ebidensya namin kasi 8 ang krimen niya. 8 ang articles of impeachment namin. Bilangin mo, 8 yan. Pagkatapos ngayon, 2 buwan pa lang, wala na. 3 na lang sa 5. Kasi tama na yun, panalo na kami. Wah! I request the Secretariat should record in our journal that I said, wah!
Silence. Silence, please, silence. Majority Floor Leader.
Thank you, Mr. President. Senator Osmeña is asking what is the swelling of what?
That's an expression.
Mr. President, again, may we call on the prosecution, find out what is the pleasure concerning the manifestation that they made yesterday?
Good afternoon, sir. Your Honor, Mr. President.
What's the pleasure of the distinguished gentleman from Iloilo?
Your Honor, as was manifested yesterday by the prosecution, that after the cross-examination conducted by the defense, we are terminating the presentation of our evidence.
Are you not, according to the newspapers this morning, the prosecution intends to present the Honorable Justice Maria Lourdes Sereno. And I also read in the newspapers that in the resolution of the Supreme Court and Bank, I think it was yesterday, the Supreme Court and Bank left it to the discretion of the good Justice Maria Lourdes Sereno to appear here voluntarily for the prosecution. And I remember that one of the panel of prosecutors, I think it was Congressman Colmenares, who informed the court that he wrote Justice Sereno to appear here for the prosecution. And I think the court is entitled to know whether you still intend to present Justice Sereno.
Your Honor, a letter invitation, as suggested by this honorable tribunal, was delivered personally to the office of Justice Sereno last Monday for her to appear before this honorable tribunal tomorrow. That's a Thursday.
Tomorrow?
Yes, sir, but we have not yet received any formal communication or reply from the Lady Justice of the Supreme Court.
Incidentally, I raised this question because I am interested to know your real position. Because yesterday you already terminated, according to the records, your presentation of evidence on Article 3 and Article 7 that you have retained among the 3 articles of impeachment out of 8 articles of impeachment covered by your pleading known as articles of impeachment. And I ask you very definitely whether you're really going to stop presenting any more witnesses on this 3 or 2 articles. And you said yes. That's my recollection, except that you reserve the right of the prosecution to present evidence on Article 2. And I understood that. I was of the mind that you were referring to the pendency of a case in the Supreme Court regarding the foreign currency deposit.
That's correct, Mr. President. We reserved that right
Will
yesterday.
you clarify really the position of the prosecution?
After yesterday, Mr. President, the prosecution met and we discussed about the pending invitation to Justice Sereno. That's why today we would like to make that manifestation that the prosecution is trying to get in touch with the Honorable Lady Justice of the Supreme Court if she is indeed willing to testify, and that if we may be given time within the week, we will communicate to the Honorable Tribunal if the Lady Justice would be willing to testify, which means, Your Honor, that we would like to reserve a right to present her if she's willing.
You are not really closing your evidence. It's open.
We are, Your Honor, we are already terminating the presentation of evidence with the two reservations. Number one,
you cannot make any reservation if you cannot close your evidence if you still have to present witnesses. The proper thing to do is to ask for continuance.
If Your Honor, please.
What's the pleasure of the...
Yesterday, I thought we were agreed together with the Honorable Court, Your Honor, that the enumerated impeachment articles, Your Honor, that were not touched upon will be considered as abandoned or dismissed.
That's true.
Not only because...
As far as the Article 1, Article 4, 5, 6, and 8. 5.
That's correct, Your Honor.
That's already effectively withdrawn.
Yeah.
That is clear. I clarified that yesterday.
And we were merely discussing, Your Honor, the modality or the means by which the same could be effected. There were some suggestions that a mere notice will be more than enough. We were of the impression that a motion to dismiss is necessary because there is already an answer filed, and as in fact there had been trial going on. So that matter of how to dismiss the four impeachment articles, Your Honor, will be effected is left to the discretion of the prosecution, Your Honor. But now comes another development, Your Honor, with this lot of reservations and so on, calling the Chief Justice Sereno to the stand. Maybe is another turning back from the original position that was manifested by the Chief Prosecutor before this Honorable Court, Your Honor. We just invite the attention of the Court on that matter, Your Honor.
Yesterday I clarified, and I think the records of these proceedings will bear me out, whether there's no question about the 5 articles withdrawn. That's clear in the record. And it was also clear to this presiding officer that the prosecution was terminating the presentation of its evidence with respect to Article 3 and Article 7. In fact, in the case of Article
2, 3, and 7.
3, Article 3, they did not only manifested that they were terminating the presentation of evidence, they cut down the allegation. They retained only in Article 3 flip-flopping. But as far as the entanglement of the defendant with the former President, Mrs. Gloria Macapagal Arroyo, as well as talking to litigants as a basis of their charge that he did not follow the stringent requirement of probity, integrity, competence, and independence. They have already also withdrawn that. They have also decided to take that out and do not present any evidence on it. So, but they made a reservation only with respect to Article 2. And that is because there is a pending case, and understandably, the court was aware of that, because there is a pending case in the Supreme Court whether impeachment is an implied exception to the confidentiality of foreign currency deposits. So I would like to be clarified.
Yes, sir. Mr. President, we are sticking to our earlier manifestation that we are we are terminating the presentation of our evidence subject to one reservation. And that is, the reservation is with respect to the dollar accounts of the Chief Justice.
Only?
Yes, sir.
And you are not going to ask Justice Sereno anymore?
No more.
Right. So,
and I just want to make a manifestation that yesterday my math was wrong. When I stated that with respect to the documents that we have marked so far, 166 documents for Article 2, 16 documents for Article 3, and 65 documents for Article 7. The total, I said yesterday, was 390 documentary evidence, but it was just 247. So 247 documents, Your Honor. And also, Mr. President, what we manifested and what we stated even outside of this honorable tribunal with respect to the termination of the presentation of evidence was that we felt that we have already presented a strong case.
All right.
And even when we, even outside this honorable tribunal, Mr. President, we're saying that it is really up to the tribunal to decide, to appreciate. And we're just stating our advocacy without prejudging the outcome of the resolution, because we have high respect to this honorable tribunal. We just want that to make, we just want that to put on record those statements, Mr. President.
All right. We accept that explanation. Now, what is your pleasure? When are you going to make your offer of evidence?
We are now...
especially documentary evidence.
Yes, documentary. We are now requesting the honorable tribunal through the honorable presiding officer to give us the prosecution until Friday this week. That's 2 days from today, within which to...
3 days.
Yes.
To
file our written formal offer of documentary evidence.
Yes, and list them down.
Yes.
And then we will also give the defense enough time to go over it with copy furnished. Huh?
Yes. We
will do that, Mr. President.
May we request, Your Honor, if it is not asking too much, a 5-day period within which to signify our objection and or conformity to the offer that will be made.
That's a reasonable request. So when you file your pleading to formally offer your documentary evidence, testimonial documentary evidence to this court in writing, not send a copy to the defense, and the defense will have 5 days
from receipt
of your formal offer in writing to file their objection to your documentary evidence.
Mr. President, we will submit our documentary offer of evidence, documentary evidence on Friday. Friday this week, that's 2 days from today. And we understand that the Senate has set a caucus also on Monday. Probably it will be reasonable, Mr. President, that to ask the defense to submit it also, if not 2 days, 3 days. For us, we will submit it 2 days from today.
Yeah, but
and if I may finish, in fact, there's already a submission of the suppression of evidence with respect to Article 2. And 166 documents pertain to Article 2. So we're just suggesting, Mr. President.
Just a minute. For the prosecution, all you have to do is actually to list these documents in some pieces of paper and list them down. But the defense, to be fair to them, they'll have to analyze what those documents are and to state their objections for their admissibility. So 5 days is a reasonable time.
We submit, Mr. President.
So ordered.
Thank you, Your Honor.
Now, when will the defense start its presentation of its evidence in chief?
We will await the ruling of this court, Your Honor, after the order is made relative to the admissibility of the offered evidence, Your Honor.
To expedite the proceedings, would it not be possible to start the presentation of the testimonial or whatever evidence the defense would make and then we will deal with the objections of the defense on the offered evidence of the prosecution?
Your Honor, please, we wanted to do that, and by way of accommodating the court, in order that the general public may not have the impression that we are delaying the proceedings in this case, Your Honor. But there are so many things that may come up, Your Honor, in our observation, opposition, as against the admissibility, for instance, of these documents, Your Honor. Insofar as the prosecution is concerned, these evidences are with them. They have examined it. They have made a formal offer of the same. But insofar as the defense is concerned, Your Honor, we have to analyze it is not enough that they are listed as being offered. We have to analyze what is the purpose of the offer. They may be admitted on certain grounds, Your Honor, but decidedly they may not be admitted in consonance with the purpose for which they are offered. That is our position, right, Your Honor.
Mr. President, if we may...
yes.
We are constrained to object to that proposal, because if we will submit our...
What proposal?
The proposal of
the chair. Of the chair?
No, it's not the chair's proposal, but the proposal of the defense to submit or to present their evidence only after the ruling of the Senate on the admissibility, if I may finish.
Yeah, that is the most...
if I can...
Go ahead, I'm sorry.
The floor. Thank you. Because if that is so, Mr. President, we asked for 2 days to submit our formal offer of evidence, and that will be Friday. And the chair gave 5 days to the defense. And if you count that, it would be Wednesday. And from tomorrow until Wednesday, if we will follow the proposal, there will be no hearing. And to us, it is a waste of time of this honorable court.
Many times,
Mr. President, that is the position. That is the position of the prosecution.
If Your Honor, please, many a times we have been over-liberal and magnanimous to the prosecution, Your Honor. They come here, no evidence, no witness, the case is, the setting is postponed, Your Honor. And we had never been heard to complain, Your Honor. We had been very accommodating. Now, if they wanted a very strict application of the rules, we will meet them on head-on, Your Honor.
But Mr.
Well, there are various evidence here presented, documentary at that. If they are overruled, if they are rejected, why are we going to touch them in the presentation of our evidence, Your Honor? On the other hand, there is even a motion filed by us to suppress and or to delete from the record, Your Honor, the documentary evidence consisting of bank records, which we feel are in violation of the rule on regarding privacy pursuant to to Republic Act 1405, Your Honor. Why will we be deprived simply because you wanted us to go the way you wanted to? There is nothing that the prosecution can impose upon this defense, Your Honor. We've never been unreasonable.
Sir, I just have to respond to that. There's a statement.
Yes,
with respect to the prosecution not being prepared, to the prosecution not ready, and to me that's uncalled for. To us, I just want to put on record, Mr. President.
I'll stake on the record of making.
It's okay if you stick on the record, but Mr. President, we want to put on record that that is unfair, inaccurate statement.
Well,
and we submit to the discretion of our honorable presiding officer.
All right. We cannot control this court cannot control the prosecution as well as the defense regarding their presentation of their respective positions on this impeachment trial. The defense is entitled to a reasonable time to prepare and assemble their evidence in order to present it orderly before this court. So, how many days after do you need to prepare for trial for the presentation of your defense?
We have left that to the discretion of the Honorable Court, Your Honor. If after a ruling had been made, we are so ordered to present our evidence anytime, we will, Your Honor. We will abide very willingly.
We will work fast to make rulings on the offered the evidence by the prosecution, so be ready.
Thank you, Your Honor.
Be ready.
Thank you, Your Honor.
Including the motion of the defense to exclude certain
documents,
the bank documents that floated around. So that's understood that you will file your written offer of your evidence formally to this court not later than Friday.
We will do that, Mr. President.
And then, upon from the time you notify the defense of the filing of your written offer of your evidence to this court, then they will have 5 days also, not more than 5 days, inextendable, to submit their objections. So ordered.
Thank you, Your Honor.
When will be the hearing? Your Honor, may we inquire when will be the hearing, if that's the case, Your Honor? Can we set at least a tentative date so that we can also prepare, Mr. President?
Mr. President. Mr. President.
The Majority Floor Leader.
Yes, may we give the other members of the court the chance to decide on this on Monday, Mr. President, during the caucus?
Yeah.
To answer that particular question.
I suggest that both sides must be ready every day for trial. You see, I am sure that you have prepared this case very well on your parts, so that there's no need to appear being taken by surprise because we are going to call the case for trial at any given day.
Mr. President, yes, we are ready, but every day. But may we be clarified if we have a hearing on Monday, if that's the case?
No.
Because they were given 5 days, which will end on Wednesday, Mr. President.
Yes.
Just for the clarification of the prosecution,
well,
Your Honor.
Mr. President, at the rate things are going, I don't think we will have a trial on Monday.
So when will be the earliest, at least a tentative?
March 12, according to the clerk of court.
March 12, Your Honor?
Yes.
March 12. March 12. Next Monday.
Because Wednesday is a 7, I suppose. Wednesday, Your Honor, is March 7.
We will be ruling on the offer on or about March 8th, which is a Thursday. And that is the reason why Monday is the most practical date, March 12th.
We submit, Mr. President.
So, the next trial date will be at 2 o'clock of March 12th in the afternoon. 2 o'clock in the afternoon of March 12th.
Mr. President, in the meantime, there is a question on whether the defense will be presenting their evidence already on March 12th, Mr. President. They should be ready. You should be ready to present on March 12th. Yes, they are. May we recognize Senator Escudero, Mr. President, and then Senator Santiago, then Cayetano, or Miriam. Senator Miriam Defensor Santiago wants to be recognized
The lady
first.
senator from Iloilo.
Thank you, Senator Escudero. The prosecution will be making an offer of evidence and then it will rest. What all this means is that after it makes its formal offer of evidence, the prosecution will then lie down in front of that first table, face down on the floor, and assume a planking position. To go rigid there. That is called planking. Because tapos ka na. Para ka nang namatay. Huwag ka nang nagsasalita pa. Tapos ka na eh. Ngayon na ako nakarinig ng we are resting our case, we are making our formal offer, we are resting our case with a reservation. Pag sinabi mong resting your case, tapos ka na. That's an oxymoron. To say that you're resting and yet you'll come alive at a certain point at your pleasure. That cannot be done. Hindi ka ba nag-trial notebook? Alam mo naman na gusto mo palang magpresenta ng isang testigo, ba't di mo tinanong noon pa? Ganon yun. To be able to deserve your appearance fee, you have to prepare for every appearance in court. Eh ngayon, pantayin mo kami ng testigo mo. Masyado ka naman swerte sa buhay, hindi ginagawa yan in law practice Ngayon ako nakakarinig nitong mga milagro na ito. Maybe it is correct that climate change has already changed everybody's heads. Because I feel like I've just been confronted by a sinkhole. I've never heard this concept before in trial court. At hanap buhay ko yun, araw-araw yun. Sari-saring sinungaling narinig ko. Yun ang hanap buhay ng judge eh. Makapo ka doon alas 8:30 hanggang alas 12:30, makinig ka ng sinungaling na parehong grupo. Kaya, magdesisyon kami sa impeachment court. If you are going to be allowed to rest but without your reservation, or if you want to file a motion for everything to be suspended while we wait for the pleasure of your witness, which is unheard of in court. It is an oxymoron to say, Your Honor, we will make a formal offer, then we will rest, which is pursuant to the rules of court, but we will rest with a reservation that we will call on our witness when she is ready. And all of you, honorable men and women, ladies and gentlemen of the impeachment court, have to wait for her pleasure and the pleasure of the prosecution. That's in effect what you are asking us to do. Ba't ninyo hinanda yan nung Enero? Eh kung yan palang testigo ninyo. Ay, kayo naman, oo, nagbibiro kayo. You gotta be joking. Pagkatapos, it will take us so much time to make our offer of evidence. Wah! For the second time. Wah! Round 2. Kasi, basahin mo lang ang Senate Journal, nandiyan ang verbatim. No offer mo of evidence. Every time you present a witness, you say, offer her for the purpose of this and that. And we will authenticate certain documents with her testimony. Nandiyan yan, di kopyahin mo lang sa Senate Journal. Anong problema mo? Have you never been in trial court? If so, can you please make way to somebody who has been in trial court before? That's not a big deal. Andiyan na yan sa Senate Journal, kopyahin mo lang yan. And besides, you should have had a trial notebook kung saan nililista mo yon. Dahil alam mo na, abot tayo sa puntong ito. Ngayon gusto nyo, mag-antay kami. Bakit is it going to tax your IQ so much that you need until Friday to make this? Dapat araw-araw yan, ginagawa yan ng secretary mo or ng clerk mo. It's all a question of just instructing her. Kopyahin mong Senate Journal, ano bang pinag-offer namin kanina? At para pag formal offer na, handa na tayo. In trial court, we don't even wait. We don't even wait for a period of time for the party to make a formal offer. Pagkatapos ng bista ngayon, bukas sabihin ng judge, mag-offer ka na. Dahil ginagawa mo yun throughout the course of the trial. What is the big deal about this? And it's highly clerical. We are only going to murmur there. Here is our witness. We offer the testimony of this witness letter A for the purpose of so and so. And these were the documents marked during her testimony, so and so. And we'll be spending the whole half day doing that kind of thing. So, this means only that either you don't know your rules of court or you're expecting or hoping for miracles to happen. Korte ni Milagrosos ito. You're waiting for a miracle to happen. Trabaho mo yan habang the trial is going on, lilistahin mo kung anong mga ebidensya mo, basahin mong sa Senate Journal, araw-araw yan, nandiyan yan Pagkatapos itong artifa ninyo, pag nag-objection ng the other side, sasabihin ka, I make an offer of proof, Your Honor, or we make a tender of excluded evidence. You do that so that the appellate court can see the records and can determine if the ruling of the trial judge was correct or not. But there is no court higher than the impeachment court. That is the express language of the Constitution. The Senate, as an impeachment court, tries and decides. So there's no point making an offer of proof or a tender of excluded evidence because no one is going to read those documents. I already implied that before, but now I'm saying it explicitly for full understanding of what is involved here. These are clerical. These are ministerial functions. Bakit ang dami na inibali ko ang defense? Mag-make siya ng motion? Dahil, ngayon pa lang niya naintindihan, having placed these things in context, kung dapat ipa-admit yon o hindi. Nag-object na nga siya noon. Pagkatapos, hindi pa iyon. Alam naman natin, gentlemen of both panels, that the general rule is, in case of doubt, admit the evidence. Ganun naman yun Kaya let's not make a big deal out of these offers. Every time a witness is presented, one of you stands up there and says, if the Honorable Court will please, we'll offer this testimony by Mr. X, and we'll mark the following documents for the purpose of. Nag-recite na kamo niyan noon, tapos ulitin pa ninyo. Yun lang parang kahirap-hirap ninyo. Ay, sus Mariusep, where are your neurons? Where are your synapses? Your brains are very, very dark. You know, when you use our brains, the electrical impulses from one neuron jumps to another neuron that is called a brain activity or a brain wave. Ngayon, kung may brain wave ka, lahat ng utak mo, kumikislap. It's entirely lighted. Ngayon, kung madilim ang utak mo, yung neurons are not working. You are flatlined. Meaning to say, hindi ba? Kung buhay pa ang pasyente, naka-jump up and down ng kanyang recording instrument. Pero kung namatay na, nag-flatline na. Yan ang nangyari sa inyo. Nagpa-flatline na kayo. I am, please, appealing to you. Can you please prepare on the rules of court? I'm very underwhelmed by all this debate about how many days to give. Dapat ngayon pa lang, anda na kayo. Part 2.
Senator Escudero, Mr. President.
Majority Floor Leader.
May we recognize Senator Escudero, Mr. President.
Mr. President, ilang paglilinaw lang po kaugnay sa mga naganap kahapon at ngayon. May I address some questions to the Chief Prosecutor or any of the lawyers for the prosecution. Your Honor, kahapon tinanong kayo ng presiding officer kung wini-withdraw ba ninyo yung articles of impeachment, particularly 1, 4, 5, 6, and 8. And the presiding officer asked you to submit a manifestation or motion to that effect. May we know if that is forthcoming?
Yes, Your Honor. We have already a draft of our manifestation, and we will file it by Friday, Your Honor.
To clarify, Mr. Presiding Officer, Your Honor, Iba ho yung withdraw sa hindi na kayo magpepresenta ng ebidensya. Ang sinabi niyo sa records kahapon, you are dropping it, you are withdrawing it, you are no longer presenting evidence. At some point you said that. May I know which one is it? The difference, Mr. President, Your Honor, is if you are withdrawing it, that means hindi namin pagbobotohan yung 8. 3 lang ang pagbobotohan namin. If you are merely not presenting evidence, nothing bars the defense from presenting evidence on all 8, and we will have to vote on all 8. May I know your intentions?
With that clarification, yesterday we said that we are withdrawing the other articles, namely Articles 8, 1, 4, 5, 6. And we will file a manifestation to that effect.
So, you're withdrawing it?
Yes.
Meaning your intention is parang wala na yun dun sa complaint?
That's correct.
Given that answer, Mr. Presiding Officer, I have more questions to ask. One, that is in effect amending the complaint. By withdrawing certain allegations, in this case, articles.
Effectively, actually, they're waiving already the
Mr. President,
5 articles of impeachment, in effect, or abandoning it. If you,
Mr. President,
if you want to use to.
if I may, that was what Congressman Agabao said with respect to Article 3, that they are standing on the testimony of their lone witness and that they will no longer present evidence on the matter and that they are solely relying on the allegations of their complaint insofar as Article 3 is concerned, plus the testimony of the witness. In this case, it is not a mere abandonment, it is a withdrawal. Because, Mr. President, Your Honor, the issues have been joined with 8 articles already. Now, there is a manner and procedure by which a complaint or pleadings can be amended. And in this case, since the issues have been joined, by leave of court. So, again, may I clarify? So it's withdrawal of the 5. So we won't have to vote on the 5 anymore.
That's the position of the prosecution. No need to vote on the 5 other articles.
That's clear.
And our position, Mr. President, is that there's no amendment to the complaint. We are simply waiving a right to present evidence and, in effect, abandoning.
Mr. President, Your Honor,
you are not
with
only
respect,
waiving a right to present evidence, you have no more right to present any
yes,
evidence.
we have no more right. We're abandoning it.
Yeah, abandon.
Abandoning, surrendering, withdrawing, dropping. Mr. President, may I know, again, this is for future impeachment processes. I hope it will not come anytime soon. But may I know, did the prosecutors consult with the complainants of the case? Because this is a substantial amendment with respect to the articles of impeachment. And I heard the good gentleman yesterday when he was interviewed, he said he consulted with the Speaker of the House. May I know, because the prosecutors, the 11-man prosecution panel, merely represent the 188 complainants. In other jurisdictions, even a mere postponement of trial, the prosecutors consult the House. In this particular instance, may I know if, and they pass a resolution to that effect, may I know if there is such a procedure taken or undertaken by the panel of prosecutors?
If it's a formal consultation with the 188 signatories, we did not. We consulted, for the record, the Speaker of the House and the Majority Leader, and we were given full discretion, blanket authority on how to present the case. It's a prosecutorial discretion. We're given that discretion, and now we are waiving a right with respect to the 5 others, and we're sticking, as the Senate President puts it, we will we'll stand or fall on the 3 articles, namely Articles 3, 7, and especially 2.
Mr. President, I do not wish to debate nor argue with the distinguished Chief Prosecutor, only to place on record that the withdrawal of articles of impeachment is a substantial decision, and to my mind, it's not merely prosecutorial discretion. Perhaps what evidence to present, which witness to present, is prosecutorial discretion, but The 8 articles were verified by 188 congressmen. They swore that they had personal knowledge or based on documents that they read it, and that they are therefore accusing the Chief Justice of all 8 acts and or omissions. My fear, Mr. President, Your Honor, is while the prosecutor, Chief Prosecutor considers this as a mere dropping withdrawal, but it would still constitute, in effect, an amendment of the complaint, which might present several other complications that we might not be prepared to encounter and face, given the problems we've been seeing in connection with this trial. I just hope that that can be clarified in your motion and manifestation that you will file, Your Honor, so that everything we do here can be used as a good precedent for future impeachment cases and students of the law. Thank you, Mr. President. Thank you.
Mr. President, we will clarify that in our notice manifestation.
Yes.
And we would like to thank Congressman
Senator
May
I suggest to the prosecutors to make a very simple, clear, and absolute statement withdrawing or abandoning whatever term or semantical terminology you will use to describe what you're doing without any further consideration, including presentation of any iota of evidence on this withdrawn articles of impeachment.
Mr. President,
yes. No, I just want to know the reaction of this.
We will do that, sir.
Right.
We will make it very, very clear.
Yes. Okay.
Mr. President, may we recognize Senator Alan Cayetano?
Mr. President, kanina po,
minority floor.
Nabanggit ng Chief Prosecutor ni Congressman Tupas na sayang yung time ng court kasi kung matagal pa yung hearing. Well taken po yun. But I'd just like to put on the record, hindi masasayang ang time kasi aside from giving the defense a fair chance to go over the submissions of the prosecution, ang daming problema ng bansa Kagabi lang, tumataas na naman ang presyo ng langis, di ba? So, may mga committee hearings naman na pwede kaming gawin at saka yung sa session, from problems sa economy, problema sa agrikultura, name it, we have it, and we'll be dealing with that. Ang question ko po, will the prosecution be needing time or will they still reply kapag if and when the prosecution, the defense submits some objections to you will submit on Friday, tama po ba? Tapos sila Wednesday. So do you need time na sagutin pa yon?
Hindi na po. Pag nasubmit namin ng Friday yon, and we will submit it kung may opposition, then we'll submit it for resolution na.
Because we're assuming na sa Thursday, makakapag-decide na po kami para mag-trial na ng Monday. But there's a big possibility na kung marami pong i-bring up ang depensa, kung 247 documents yan, matinding review at saka pag-uusap pa ang gagawin namin. So I just wanted to know whether so submitted nyo na as far as you're concerned kung ano ibibigay nyo sa Friday. Then we will deal with their with their objections. And then then the court will make the decision.
Tama po yun, Mr. President.
Thank you, Mr. President.
Majority Floor Leader.
Yes,
Mr. President,
The gentleman from Ilocos Sur.
may we request, Mr. President, there was a statement here earlier made by the good lady from Iloilo referring to the prosecution as gago. Baka naman po pwedeng matanggal yon dahil baka hindi naman po maganda sa posterity natin na nababasa po yon na natawag po kami na...
No objection, Mr. President.
Thank you, Madam. Thank you, Mr. President.
All right.
Mr. President,
Strike the term G-A-G-O from the record.
Mr. President, may we recognize Senator Ralph Recto?
The gentleman from Batangas.
Thank you, Mr. President. Mr. President, just a clarification. I heard earlier that we come back on March 12. Is that correct, Mr. President? That means for 1 week next week there is no sessions.
We will resume the trial of this impeachment case on March 12 at 2 o'clock in the afternoon.
That is right. And that would mean, Mr. President, that we would have 2 session weeks left until March 23. Looking at the schedule of the impeachment court as well, and that of the Senate and the House of Representatives, we come back on May 7, if I'm not mistaken. And I've heard from the defense that they need something like 5 or 6 weeks to present their evidence in behalf of the defense.
We cannot deny them that.
Yes, I'm not denying them that, Mr. President. I'm just looking at the schedule of this impeachment court, and looking at that, then it is possible that we will not be through by June 7, Mr. President. Because we only have 4 session weeks left when we get back on May 7. So if we come back on March 12, we only have 6 session weeks left, Mr. President. Is it correct to hear from the defense that you would need something like 6 session weeks?
I have not estimated yet, Your Honor, because that will depend on the developments after the striking out or the abandonment of the 4 impeachment articles, Your Honor. 5 articles. I
only mentioned this, Mr. President, for the consideration of the impeachment court with regard to our schedule as well, so that all of us will know what is in store. So thank you, Mr. President.
Thank you also.
All right. The lady Senator from Taguig.
Mr. President, this is just a follow-through on the concern raised by Senator Miriam Defensor Santiago and Senator Chis Escudero on the withdrawal of the 5 articles. Mr. President, I direct the attention of the prosecution to our rules of court, which have supplementary effect on these impeachment proceedings. Rule 10 on amended and supplemental pleadings clearly states that pleadings may be amended by adding or striking out an allegation. And this can only be done subject to Section 2 and Section 3, wherein Section 2 states that an amendment is a matter of right before a responsive pleading is filed. We all know that the responsive pleading has been filed, and therefore it is Section 3 that comes into effect, which states that the amendments can only be made with leave of court, except as provided in the next preceding section, substantial amendments may be made only upon leave of court. This refers to civil proceedings. If we will look at the rules on criminal proceeding, then I will make reference to Rule 110, Section 14, which states amendment or substitution. A complaint or information may be amended in form or in substance without leave of court at any time before the accused enters his plea. After the plea and during the trial, a formal amendment may only be made with leave of court. So in both cases, Mr. President, whether you consider this impeachment proceeding as close to a civil proceeding or close to a criminal proceeding, both require leave of court. So I sincerely suggest and request that the prosecution takes this into consideration when they when they file the appropriate manifestation or clarification next week. Thank you very much.
Well, I just want to state this for the record and for the consideration of the members of this court as well as of the 2 panels of lawyers representing both sides of this impeachment trial. While we are a court of record, we are not really strictly a court that maintains a record for purposes of appeal, because there is no appeal in this case. And so, therefore, we are blazing a new trail. Though the rules that were mentioned, in my humble opinion, are not applicable to this particular proceeding because there's no assignment of errors to be thought about for the future, because there is no appeal lying in the decision of this court. Either we pronounce the respondent guilty, or we say he's not guilty, and either side, no appeal, lying. The end of the matter will be the verdict of this court. Unlike in an ordinary civil proceeding,
civil case or in a criminal case, if the defendant is convicted, he can appeal to a higher court and assign reviewable errors of the lower court. Or in a civil case, whoever loses in the civil case can appeal the case and assign reviewable errors in his appellate pleading. In this case, there is no appeal. So, whatever we say with respect to the evidence, with respect to the admissibility of evidence, ends there. They're recorded for reference purposes, but the verdict will be rendered by this court on the basis of the appreciation, final and ultimate appreciation of each of the members of the Senate sitting as judges, jurors in this. That's why I called it jurors, because each one of us will form a judgment of this case, of the respondent. Once that judgment is rendered, we count the number of votes that will vote in favor of acquittal, as well as the number of votes involving will be in favor of pronouncement of guilt, and if it is guilt, whether we attain the two-thirds vote, which is an absolute 16 of all the members of the Senate. So all of these discussions are for our own guidance. But since there is no reversible error in this proceeding, because there is no appeal, we will take the bull by the horn when we reach the bridge, so to speak. Okay?
Thank you.
Your Honor, please.
Mr. President.
We understood the position of the Honorable Presiding Judge, Your Honor, but there seemed to be some plausibility on the statement made by the Honorable Senator Pia and Senator Miriam Defensor Santiago, Your Honor, because what is involved in their articulation, Your Honor, or postulation, are merely rules of procedure, Your Honor, not on the validity of whatever judgment this court may render after trial on the merits. The issue that was posed a while ago is what mood must be taken, must be followed in connection with the non-discussion anymore, or non-taking into consideration of impeachment articles 1, 4, 5, and 6, and 5 articles, Your Honor. We have not yet reached that stage, Your Honor, where a judgment on the merits had been rendered. So, the way I understood it, because there is no definite rule in so far as this kind of eventuality is concerned, provided for under the rules of the Senate, Your Honor, then there is no harm adopting the rules of procedure enshrined under our rules of court. I fully agree, Your Honor, to the effect that if there is already an answer, meaning an adverse pleading, then a mere statement on record or an oral manifestation will not be enough for the dismissal or disposition of those abandoned articles of impeachment. Because the law requires, per procedure, Your Honor, that it must be subject to a motion and approval. A motion is not enough, Your Honor. Even a mere notice is not enough in my assessment.
Precisely, I made it clear that there will be no evidence being presented on those articles, and second, there will be no judgment on the pleading. If you remember, I asked that question from the prosecution yesterday. So, but I will not begrudge and take it away from the defense to use whatever material evidence they have with respect to Article 1, Article 4, Article 5, Article 6, Article 8 to be used for the defense of
Peer record.
I charge this private prosecutor with complaint of this impeachment court. I have the evidence right here, taken in a video by Senator Alan Cayetano. And to say, nasasaktan ng tenga ko, should have been cause for you to walk out of this courtroom with permission of the court. But you cannot make those contemptuous gestures in front of a judge and get away with it. I submit, Mr. President, that this should be taken up.
To be fair, I'll give the counsel a chance to explain himself.
Your Honor, kasi po sinasabi ng kagalang-galang na hukom na ngayon lang daw po nangyari na ang isang complaint ay wini-withdraw or ng prosecution or ng sino man. Pero yan po ay natural po yan sa court practice. Nangyayari po yan araw-araw naman nagwi-withdraw ang isang abogado ng kanyang complaint or ng part na complaint nag-amend. But the fact, Your Honor, please, that this is the first time that I experience in my 40 years of practice na ang isang judge ay nagle-lecture sa mga abogado. Hindi po ata tama yung mga ganun eh.
Bakit hindi ho kayo tumayo nung nagsasalita si Senadora Miriam para mag-object?
Hindi po ako, wala po akong karapatang mag-object sapagkat kung kailangan pong i-recognize muna ako ng kagalang-galang na impeachment court nito upang masabi ko kung anong nasasaloob ko. Pero nang nandito na po ako ngayon, di sasabihin ko po ang nasasaloob ko.
All right.
Mr. President, I reiterate my motion to cite for contempt by the impeachment court, not by me, but by the impeachment court. Imagine if all the lawyers did that in front of the impeachment court, if one of the senator judges took the forum to express his opinions. Kasi salungat sa gusto mo, kaya ayaw mo pakinggan. Kung ayaw mo pakinggan, umalis ka sa korte.
Aalis na nga po sana ako eh, kaya lang...
Granted! If that is in the form of a motion, go ahead! Nangahamon ka!
Aalis na po ako.
Dito ako nakaupo eh. Gaganyan ka sa akin?
May I suggest that...
And it's on video.
May I suggest that let us be calm in this proceeding and deal with one another in a fashion that will not create an impression before the people that we are not following the right norms. Please
May I say something, Mr. President?
Explain yourself.
Kung nakasakit mo po yung isang aktuasyon ko po, I really did it purposely. Because totoo naman po na talagang shrill ang voice na nasasaktan ng tainga ko eh. Ang kuwang ko lamang po ay dapat po lamang na kahit ang mga senador, mga judges at kami mga hamak lamang prosecutor dito, ang pinaka-importante po sa isang tao ay respeto. Ang kung nagdedemand ka ng respeto, dapat respetuhin mo doon itong mga abogadong ito. Sapagkat yung human dignity, wala pong katulad dyan.
Now he's lecturing me.
Trial suspended for several minutes.
Okay, nawalan tayo sa impeachment. Napunta na tayo sa... Ayan, nakikita natin na nilapitan pa ni Senator Santiago itong si Atty. Vitaliano Aguirre. Which is din, di ba? Isa rin kilalang
kanina
abogado.
Kanina napanood nyo rin yung ginagawa.
Criminal lawyer siya. Oh.
Yeah, no, I was
pero napasinan natin
no?
din natin na akala natin kung hindi sadya, pero buong panang camera natin
talagang nakita naman siya na gano'n eh.
So is this a contempt? Okay, ngayon po ay patuloy na naka-recess muna dahil na sidetrack tayo dito sa...
Kanina Iga, nakita natin si Attorney Vitaliano Aguirre na lumabas na ng session hall.
Pero dapat mag-react dito ang impeachment court kung contempt. Ano ba din? Kabasusan ba yun?
Sa tingin ko, no, I mean, medyo nagulat din ako sa ginawa ni Attorney Aguirre. I mean, naintindihan ko yung kanyang pakiramdam, no? Pero may paraan naman na tama doon nung ginawa ni Congressman Fariñas kanina.
Dito kayo din siya, to
no,
strike.
You don't have to subject yourself. Hindi naman kailangan na tanggapin mo yung sinasabi ng korte. Pero may paraan na sabihin mong hindi dapat gano'n.
Pero doon hindi ko alam bakit hindi siya nakikita ni Senadora Miriam dahil nakaharap.
Buti nga.
Si Senator Jinggoy pang pumuna. Akala natin palalagpasin na nila no?
And I think si Senator Alan Peter Cayetano took a video at pinakita niya kay Senator Miriam Defensor Santiago nga kanina.
Pag gumanon ba ang isang private prosecutor, hindi lang si Senador Miriam ang ano nito, no?
Hindi, yung court mismo.
Yung court mismo. Okay, tingnan natin karagdagang mga balita. Nandun mismo si Sherian Torres. Anong nangyayari ngayon dyan?
Yes, Arnold, Cara, sa mga oras na ito, no, pansamantalang sinuspindi muna yung pagdinig yung trial dito sa may session hall dito nga sa impeachment trial. So ay matapos na kumprontahin nila Senadora Jingo Estrada at ito na rin mismo si Senadora Miriam Defensor Santiago, itong si Attorney Vitaliano Aguirre II. At kanina nga nakita natin yung paghingi ng explanation nitong si Senate President Juan Ponce Enrile dito kay Attorney Aguirre na umamin naman na talaga daw na nasasaktan siya doon sa mga naririnig na bilang bahagi ng prosecution panel mula dito kay Senadora Santiago. At sabi nga niya kanina, Igan, ay sabi niya ang tangi lamang daw na hinihingi nila ay yung pagbibigay sa kanila ng respeto, lalo pa at sila naman ay mga practicing lawyers. No? Matapos ito, Igan, ay agad na nagdeklara ng recess o ng pamamahinga muna ng pagdinig itong impeachment court at itong si Senadora Santiago ay agad na lumapit dito kay Attorney Aguirre at face to face na paulit-ulit niyang sinasabi na hinahamon mo ko, anong gusto mo mangyari? At nung ilang sandali na agad na lumapit itong mga kapwa mambabatas nitong ni Senadora Santiago, no? At pinigil na siya, pilit siyang inilayo dito sa rostrum kung saan nakatayo itong si Attorney Aguirre. At pagtalikod naman itong si Senadora Santiago, itong si Attorney Aguirre ay tahimik na lamang na umalis ng session hall. Sa ngayon, itong si Senadora Santiago, Igan, kung makikita natin ay patawa-tawa na nakikipag-usap, nakikipagkwentuhan dito kay Senadora Pia Cayetano, Loren Legarda, at itong si Senador Alan Peter Cayetano na siya daw kumuha nung video na nagpapakita nga na nagtakip ng kanyang tenga itong si Attorney Aguirre. So sa ngayon, Igan, nakasuspindi pa rin ang pagdinig nitong impeachment court at tayo ay naghihintay ng pagtawag ni Senate President at Presiding Officer Juan Ponce Enrile ng resumption ng hearing. Igan?
Doon sa vantage point ba ni Senator Miriam, hindi niya napapansin yun?
Kung titignan mo kasi, Igan,
Nasa gilid, no?
medyo matatakpan, no?
Natatakpan.
Medyo takip itong si Atty. Aguirre kasi nga nakaupo siya, tapos may nakaharang na isang rostrum. Ito yung tinatayuan ng prosecutors. Tapos ang katapat ng rostrum na to, yung tinatayuan naman ng senator judges na madalas naman na pwestuhan ni Senadora Santiago.
Nag-usapan nga namin dito, siya sana nagdahilan na lang siya na masakit
talaga tenga niya.
Pero inamin niya, naiirit na siya sana.
Oo, kaya lang, Igan, kanina talaga, nung habang medyo mahaba talaga yung naging dressing down binigay ni Senadora Santiago, no? Sa bawat pagtayo talaga ni Senadora Santiago ay nakita natin na talagang nagtatakip siya ng tenga. At kanina, nung sinisita na siya, ang mga members ng panel ay bumubulong na. Medyo malakas naririnig natin dito sa kinaroroonan natin na mag-apologize ka na lang. Yun nga, at biglang lumapit si Congressman Tupas at hinihima siya sa likod at binubulong, sige na, mag-apologize ka na. Yun nga yung sinabi niya kanina na ang sinasabi nga niya, kung ako man po, kung nakasakit man po ang aking ginawa, ay parang sabi niya, sinadya ko po yun. So, to the surprise of the other prosecution panel members.
Yun na
Okay.
nga. Okay, maraming salamat.
Sherry Ann Torres.
Ay, Andiyan ka ba sa linya? Kasi baka yung blood pressure ni Senator Miriam.
Parang patawa-tawa naman si
siguro.
Senator Miriam Defensor Santiago ngayon.
Kasi
pero, Dean, so ano yun? Bawal talaga for...
Ay, teka muna, si Sandra Aguinaldo, baka kasama si Atty. Aguirre.
Kasama niya si Atty. Aguirre.
Yes, Igan, Kara, hindi pa tayo allowed na makalapit ngayon kay Attorney Vitaliano.
So, nandiyan pa siya?
Pero narito siya ngayon sa loob ng kwarto ng prosecution team dito sa Padilla Room, Igan. At narito rin tayo ngayon, mga ilang miyembro ng media. Pero sa ngayon ay nasa loob pa siya ng isang maliit na kwarto at kasama yung mga iba pang private prosecutors. Dinala siya dito, Igan, as soon as makita nyo sa video, di ba, na kinumpronta siya o kinausap siya nito si Senator Santiago. Soon after ay in-escort na siya palabas ng Senate security at dinumugga ng media paglabas niya doon mula sa session hall at in-assist na siya papunta dito sa Padilla Room at sa ngayon ay nagpapakalma
diba, Sandra,
doon sa ilang kasama niya kanina, Yasigan.
Pag-contempt, di ba, may jail term doon sa Senado, sa holding area?
Oo, Igan, kung tuluyan na siya talagang mako-contempt ay kadalasan ang nakikita nating practice nilalagay sa isang kwarto at kung siya na may karamdaman ay minimake sure na talagang siya ay nababantayan ng mga doktor. Sa ngayon naman, Igan, ay tahimik dito sa loob ng Padilla Room. Yung mga congressmen, wala dito, Igan, kahit na prosecution room to. At sila ay abalang-abala. Nandun sila sa loob mismo ng session hall para nga kausapin din itong mga senador, Igan.
Si Kara, baka... Okay na. Okay. Maraming salamat, Sandra Aguinaldo. Ayan. Ang dami kong tinatanggap na reaction dito sa ating mga nanonood. Sana daw umalis na lang at kung ayaw nyo mapakinggan.
Oo nga po, sir, kapag kunyari gano'n na hindi mo matik or hindi ka sang-ayon dun sa sinasabi ng isang senator judge, hindi ka talaga pwedeng magtakip ng or mas maganda, o lumabas ka na lang?
Lumabas ka, o maaaring mag-object ka. Kaya di ba sinabi kanina sino ba nagsabi?
Congressman Farinas.
At sinabi ng isang senator judge na, ba't hindi ka nag-object? Di ba? Pwede mo naman kasi
sabihin. Pero di ba through a prosecutor, hindi private? Kailangan ba sila tumayo?
Pwede naman sila mag-object to the o sinabi nila sa prosecutor, sa House prosecutor na mag-object ka naman, di ba? Maganda yung ginawa ni Congressman Farinas kanina. Kahapon napansin nyo si Congressman Colmenares din, si Neri, palaging inaatake, di ba? Pero hindi, talagang consistent na siya, magalang siya.
Very calm.
Sa tingin ko, lumabas siyang mas mabuting abogado.
Mas magnanimous.
Mas magnanimous, mas effective dahil doon.
Lalo na itong sina Atty. Aguirre, ito yung mga huling list ng private prosecutor, hindi ito yung mga unang
Naalala ko nga for some reason, naalala ko actually si Pepe Jokno in the height of the Marcos regime, yung talagang napang-api, yung napaka-bias na mga judges, tinuturo niya pa rin, kailangan mo igalang yung judge, yung korte igalang mo. Kasi
hindi
kung
hindi mo
the moment kasi na hindi mo gagawin yan, magbe-breakdown lahat.
Yung sinasabi naman, yung posisyon naman ni Attorney Aguirre kanina, na sinasabi niya, hindi daw tama yung pagtrato ni Senator Miriam Defensor Santiago sa mga judges, sa mga prosecutors na masyado naman daw nakapanliliit na. Valid po ba yon na
sa tingin ko, no? I mean, nang ginawa din yun, di ba? Actually, sinabi din niya ni Justice Cuevas sa isang interview a month ago, na sabi niya, yung masakit daw yung loob niya pag nakikita niya ginagawa yun sa mga prosecutors. Okay. Na hindi naman talaga dapat, lalo na congressmen din sila, may constituencies din sila. But even as ordinary lawyers, di ba? Yung ano. But Senator Santiago is like that. We know that. Alam naman natin yon, di ba? Sa tingin ko, tatanggapin na lang natin yon. Para sa akin, national treasure si Senator Santiago, with all the idiosyncrasies but also with all the talent, di ba? So, tanggapin na lang natin yon at parang i-discount na lang natin, parang ibigay mo na lang sa kanya na meron siyang ganong klaseng language. But hindi naman tayo kailangan mag-respond bilang na gano'n na tulad sa kanya.
Yung mga congressman kasi hindi pwede mag-react ng ganun kasi may interparliamentary courtesy pa rin sila, no? Kahit na sila prosecutor and senator judge, talagang nagre-respetuhan pa rin sila.
Ni-raise na yan ng House of Representatives na sa palagay nila dapat hindi naman daw sila kinakausap ng gano'n na masyadong pinuput down at tinatawag ng kung ano-anong mga pangalan.
Exactly.
Dahil pareho naman silang
kung napansin mo,
legislators.
pag tama yung pasok mo, tulad ni Congressman Farinas, binawi ka agad. Alam naman ni Senator Miriam na mali yung sinatawag niyang gago yung yung mga prosecutors. Kaya nung ni-request na strike it down, yes, no problem.
Okay, balikan natin talaga yan. Samantala, tuloy-tuloy po ang balita natin dito sa GMA News TV.
Ang News TV Live ihahatid sa inyo ni Trisha Zafra.
Maraming salamat, Arnold at Kara, na itala kahapon ang pinakamalaking bulto ng mga taong sumakay sa LRT Line 1. Ayon kay LRTA spokesperson Atty. Hernando Cabrera, umabot sa mahigit 685,000 na pasahero ang sumakay sa kanilang linya dulot ng Grand Evangelical Mission ng Iglesia ni Cristo. Paliwanag pa ni Cabrera, marami raw ang nagtiyagang pumila sa LRT Line 1 dahil sa hirap sumakay ng bus. Nag-extend naman ang kanilang biyahe ang LRT Line 2. Sa kuha naman ni Hughes Cooper Rene Carandang, kitang-kitang mahabang pila ng bus at sasakyan sa kahabaan ng Rojas Boulevard. Bukod pa rito, napuno rin ito ng mga taong papunta sa naturang pagtitipon. Tumagal daw hanggang alas 10 ng gabi bago nag-alisan ang mga nakaparadang bus sa lugar. Isang improvised explosive device o IED ang nadiskubre ng pulisya sa Calibo International Airport. Nadiskubre raw ng security staff ng paliparan ang pampasabog sa isa sa mga bagaheng kanilang iniinspeksyon. Pinaniniwalaang dinala ito sa counter ng isang cargo forwarding company. Ligtas naman itong na-detonate ng mga otoridad. Patuloy ang investigasyon ng pulisya sa insidente. Bukod sa airport sa Katiklan, isa ang Calibo International Airport sa mga dinaraanan ng mga turistang gustong bumisita sa isla ng Boracay. Isa pang round ng oil price hike ang humabol sa buwan ng Pebrero. Kaninang hating gabi tumaas ng 50 sentimo ang kada litro ng gasolina at diesel ng Eastern Petroleum. Sumunod naman ang oil price hike ng Phoenix Petroleum kaninang alas 6 ng umaga. At yan po ang iba pang malalaking balita sa oras na ito. Para sa News TV Live, ako si Trisha Zafra. Balik sa inyo, Arnold at Kara.
Maraming salamat, Trisha Zafra.
Okay, balik din tayo sa ating talakayan. Kasama pa rin si Dean Lavinia at
Dean, kapag kunyari ma-cite in contempt nga itong si Attorney Vitaliano Aguirre, ano mangyayari? Ano bang parusa kapag na contempt of court ka?
Kulong yata.
Pwede naman reprimand lang.
Okay.
Pwede yung pakulong overnight. Diyan na naman sa Senado gagawin. Pwedeng i-ban na siya. Hindi na siya pwedeng
umarap dito sa trial
court.
na to.
Range naman. No? Sa tingin ko yung gano'n naman siguro, yung reprimand lang yun na wag nang ulitin.
At pwede bang isang
First
senator
offense.
judge lang ang mag-rule nito or the whole house has to vote on
sabi
it?
ni Senator Santiago, diba, I accuse you and I ask the impeachment court.
Not me. Oo.
It's not me who cite in contempt the impeachment court.
May implication ba ito sa kaso? Wala naman.
Sa kaso.
Malayo to.
Pero kung hahayaan lang nila ito, baka sa mga susunod na pagbabalik na may
mas mainit lang ang ulo.
Hindi, kaya
kailangan
kailangan magiging firm din sila dito, no, yung impeachment court.
Pero sa sa ordinaryong korte,
Nililecturean ba talaga ang mga abogado?
Pag binasa yung yung final decision, di ba? Tinuturo pa ng judge ano mga loopholes mo.
Kasi si Senator Santiago has always behaved like that, even in her court 30 years ago, 25 years ago.
Nasubukan nyo na po ba yan? Na-lecturean na rin po ba kayo dati?
Lawyer, naging abogado ako kasi nakita ko si Judge Defensor Santiago at si then Professor Heidi Yorak in court, no? Si Judge Santiago yung judge, yung prosecutor, yung mga pro-Marcos na prosecutor na palagi niyang pinapagalitan din, tulad nito. Siyempre, cheer ako ng cheer sa kanya kasi anti-Marcos ako at activist ako, di ba? She was always like that. Kaya, para sa akin, i-discount mo na yan kay Senator Miriam. Tanggapin na natin na ganyan siya. With all the negative things, but all the positive things also that brings. So, wag na tayong magalit sa kanya.
Okay. Pwedeng iwan na muna natin yung
issue
doon
na
sa
yan.
issue na tayo. Sa pinupunto nga po din ni Senator Santiago, tama rin naman siya na punahin parang nilalaro daw, no, yung korte ng prosecution at parang ang dating we withdraw, parang laban bawi, no?
Kasi nagbigay ng
pero merong reservation.
Yeah. Pwede po ba yun, sir, na iterminate mo yung presentation mo ng evidence or i-abandon mo na yung ibang articles? You rest your case pero you have reservations?
Pwede naman basta maging malinaw lang sa'yo kung bakit, di ba?
Okay.
Medyo naman justified yung reservation kasi tungkol yun sa
dollar account.
Tungkol yun sa dollar account na may pending pa na court decision. Sa tingin ko yung nangyari dito, yung heart talaga ng problema ng prosecution. Palagi kong sinasabi actually dito, sinusulat ko na yun ang mahirap sa case nila dahil wala talaga silang evidence. In-impeach nila yung Chief Justice. So now they had to gather evidence during the trial. Hirap-hirap yung gawin. Dapat talaga nag-gather sila ng evidence dun sa house na may control sila sa proceedings, di ba?
Yes.
So ngayon, that's why ina-amend nila yung kanilang kasi na-discover nila wala silang evidence sa ilang mga artikulo, di ba? Lalo na nagbarikada ang Supreme Court, di ba? Importanteng usapin din yung kanina yung sinabi ni Senator Alan Cayetano na kailangan natin pag-usapan itong issue na ito kasi in future impeachment, paano natin, di ba, makahanap ng evidence sa Supreme Court kung magbabarikada yung Supreme Court ng judicial confidentiality. So, talagang importanting issue yan na dapat talakayin din ng impeachment court, even for precedent's sake, kahit hindi not for this particular case.
Kasi ang sinasabi ni Senator Alan Peter Cayetano kanina na the impeachment court in a way is supreme over the Supreme Court pagdating sa impeachment. Kasi sila lang ang may karapatan na maglitis ng kung ano mga wrongdoings supposedly ng mga justices.
Pero sa tingin ko, kung nagkaroon ng pagkakataon ng hearing sa House na sila ang nagdiin ng mga rules, di ba? Ng evidence. Sa tingin ko na gather sila ng evidence na pwede nilang dalhin sa Senado.
Okay.
Din
ito, mukhang bumalik na yung nag-resume na yung impeachment trial. Panoorin po natin ulit.
As a shining example, I would like to think of what the law practice is supposed to be like. Mr. President, every bar examinee knows that utmost respect is due the judge as soon as a lawyer walks into his courtroom. In fact, even outside the courtroom. A lawyer may disagree with the court, Your Honor, but he is not. He is never allowed to display such arrogance and disrespect towards the court. Mr. President, the rules are very clear. Section 1 under Rule 71 states, direct contempt punishable summarily. A person guilty of misbehavior in the presence of or so near a court as to obstruct or interrupt the proceedings before the same, including disrespect towards the court, may be summarily adjudged in contempt by such court and punished by a fine not exceeding 2,000 pesos or imprisonment not exceeding 10 days or both, if it be a regional trial court or a court of equivalent or higher rank, or a fine not exceeding 200 pesos or imprisonment not exceeding 1 day or both, if it be a lower court. Mr. President, I second the motion of Senator Miriam Defensor Santiago to hold the lawyer in contempt. We will hold under advisement the actual and the appropriate penalty for this contemptuous act. I so submit, Mr. President.
All right. May I...
Mr. President, if I may also add, in the meantime, I move that he be excluded from this impeachment trial court.
Is the counsel for the prosecutor still present in the courtroom?
He's not anymore here inside. He's not anymore inside the courtroom,
yes,
Mr. President.
This presiding officer, before he makes a ruling, would like to say something. If you remember, at the beginning of our proceedings, I made an opening statement, and I requested everybody, especially the lawyers on both sides, because I know that it is not far-fetched that things like this would come before us, considering the passions, the heat, the intensity of emotions that will arise in the course of this proceeding. And indeed, today we have witnessed a direct indication of a disrespect by a member of the bar to this court. And while in all my years of trial and professional practice, I have appeared before many of our stern judges in this country, and many of them were very stern. We were taught to practice a behavior, a professional behavior of utmost control and respect to the dignity of the court before whom we appeared. And I must say that I cannot tolerate any disrespect of this court and to any member of this court as a presiding officer. Maybe my fellow lawyers will think of me as an old head in this profession, a traditionalist, but that is the norm that I have learned from my first year in College of Law of the University of the Philippines all the way to the time that I entered public service at the height of my active law practice. And so, indeed, there is a ground.
Mr. President.
Just a minute, may I request the lawyer not to interrupt his court?
I'm sorry, Mr. President.
Yes. Please sit down, Mr. Counsel. There must be an order in a courtroom. You can rise after the presiding officer in the court has spoken. Now, there's a motion to cite a member of the prosecution panel for contempt, and that motion is duly seconded, and it cannot be set aside. And indeed, the person concerned was given a chance to explain what he did and why he did it. And he openly admitted in court that he did it purposely because he felt offended. And so therefore it was a sign of his disrespect to a member of this court, and that cannot be allowed to pass. And it must be dealt with accordingly, according to the rules applicable in this particular circumstance. And so therefore, what is the pleasure of this court? I am not the court. I want the pleasure of this court.
Mr. President, I have seconded the motion of the Honorable Miriam Defensor Santiago, and I believe our colleagues are all supporting this motion, Mr. President.
Any objection to the motion? Hearing none, is there anyone in the prosecution that would like to make a statement?
Yes, Mr. President. Precisely, I wanted to rise earlier, and I'm sorry for the interruption, because on behalf of the prosecution, we would like to express our regrets for what happened to the Honorable Court, especially to the lady from Iloilo, for what happened. The private prosecutor is under our control, so we feel that we have to express our regrets, Mr. President.
Yes, the prosecution panel, like the provincial or city fiscal in the prosecution service of the government, is always in control of the case of the government against an accused. A private prosecutor cannot do anything without the control of the prosecution panel. And it was your responsibility to see to it that the private prosecutors that you bring into this courtroom to assist you in the prosecution of this impeachment trial will carry themselves according to the norms of the profession and the conduct that they ought to practice inside a courtroom. So, given your apology, we'll accept it, but nonetheless, we will enforce respect to this court. And so, if there's no objection to the motion of the lady senator from Iloilo, and seconded by the lady senator from Taguig, the gentleman who is a member or the private member of the prosecution panel is hereby cited for contempt, and the penalty that will be meted by this court against him will be taken up in a caucus by this court next week.
Mr. President.
Thank you.
From here on, all concerned must take note of this. We will no longer tolerate a misbehavior like this. If you want to participate in this proceeding, we are welcome. But if you do not believe in the dignity of this court or its jurisdiction over you, if you think that you're better than us, as lawyers, you are better than us, well, we are entitled to your opinion, but we will enforce the rules of procedures that are applicable in a court like this. So ordered.
Mr. President. Mr. President.
Majority Floor Leader.
Thank you, Mr. President. Related to that, I move that the caucus of the Senate as an impeachment court be moved on Tuesday at 12 noon.
Any objection? Hearing none, the motion of the Majority Floor Leader is approved.
Also, Mr. President, may I move that the Senate legislative session, which is scheduled on Tuesday at 9 o'clock in the morning, be moved to 3 o'clock in the afternoon. On that same day, Tuesday, after the caucus, Mr. President, Tuesday.
The chair hears none, the motion of the Majority Floor Leader in moving the legislative session of the Senate in the morning to the afternoon of Tuesday is approved.
Thank you. Mr. President, acting on the request of the prosecution, a subpoena ad testificandum et duces tecum was issued to Attorney Harry Roque of the UP Law Center on February 27. Yesterday, the prosecution filed a motion to withdraw the subpoena issued to Attorney Roque for the information of the court.
Noted.
Also, may we place on record the explanation of both of Senator Francis Pangilinan on the resolution of the impeachment court of the issuance of subpoena to Associate Justice of the Supreme Court, Mr. President. I so move that placed on record. the vote, explanation of vote be placed on record, Mr. President.
Noted.
Mr. President, may I ask the Sergeant at Arms to make an announcement?
The Sergeant at Arms may now make an announcement.
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Mr. President, I move that we adjourn until 2 o'clock of Monday, March 12, 2012.
Is there any objection? The chair hears none. The trial of this impeachment case against the Chief Justice of the Supreme Court will be adjourned until 2 o'clock in the afternoon of Monday, March 12, 2012.
Okay, maraming salamat. Balikan agad natin si... wala pa.
So March 12 pa ang balik dahil by Friday...
And contempt. Pero hindi pa siya
Okay, balikan natin Senado si Sandra Aguinaldo. Sandra?
Yes, Igan.
Go ahead.
Igan?
Yes, go ahead.
Right now, ngayon ay nandito pa rin sa loob ng prosecution room itong si Attorney Vitaliano Aguirre at inaantabayanan yung posibleng pagbibigay niya nga ng statement dahil ayon na rin dito sa prosecution, ilang miyembro ng prosecution team ay lalabas na to any moment. Now, ang kasama niya, Igan, dun sa loob ng, parang dito sa loob ng Padilla Room, Igan, meron kasing maliit na room pa dito. Walang access ang media ron, bantay sarado ng house security. Hindi namin siya malapitan sa ngayon. At kasama niya sa ngayon yung mga kapwa niya, private prosecutors, at kanina nga daw ay pinapakalma ito at pinagsabihan na rin na wag muna tumanggap ng mga tawag at katanungan mula sa media, Igan.
Okay, so nandiyan pa siya, si attorney.
Oo, right now, Igan, narito pa siya sa loob ng Padilla Room. Pero sa isang briefing area naman dito sa Senado ay ongoing na yung briefing ng prosecution team. At sila nga po ay nagpapaliwanag tungkol dun sa mga naging action ditong si Attorney Vitaliano Aguirre. Pero kanina ma-share ko lang, Igan, nagpahayag din si Congressman Sani Angara na talaga namang nasaktan din sila doon sa mga anilay masasakit na salita na binibitiwan ng ilang senador. Kaya maaari daw hindi nakapagpigil itong si Attorney Vitaliano Aguirre. Ganun pa man ay hindi daw naman nila tinotolerate yung ginawa nito ngayong araw. Igan?
Okay, pero alam na niya na na-contempt na siya ng court at sa caucus yata pag-uusapan yung parusa niya, Sandra?
Yes, Igan, kasi dito sa loob ng prosecution room ay maraming mga TV, no, yung mga direktang naka-hook up dun sa mismong sa session hall kung saan nagaganap yung pagdinig. Kaya rinig na rinig niya yung naging ruling ni Senate President Enrile. Igan?
Okay, maraming salamat, Sandra Aguinaldo, mula po sa Senado.
Okay, so i-recap lang natin yung nangyari kanina. So the prosecution panel magsusulat at magsusumite ng written formal offer of evidence by Friday. After that, bibigyan ng 5 araw yung depensa para mag-submit ng objections nito. At ang resumption ng trial ulit ay March 12
March 12. 1 week tayong...
1 week.
Naka-recess.
Recess din tayo dito.
Okay. Si Dean Lavinia kasama pa rin natin. Hindi lang pala tinakpan yung tenga, pinalakpak pa yata. Hindi na, no? Medyo siya, masyadong animated yung nakita natin.
Naintindihan ko din naman. Kasi syempre, human beings din tayo lahat, di ba? Pero yun na nga, yung sinasabi ni Enrile, ganun talaga yun. So, kung kung ikaw yung lawyer, di ba? Kailangan mong di ba, yung pikon ang matatalo
Oo.
Ganun naman
pikon
talaga.
So,
napikon siya, di ba? May ibang paraan naman na mag-respond.
Kung meron kang objection, meron namang or kung hindi mo gusto yung naririnig mo, merong mga paraan para i-manifest mo yung objection mo.
Exactly. Kasi ba't yung iba namang katabi niya nakikinig?
Yung iba, nakikinig na
yung iba,
naman.
naglalaro.
Tapos kanina nga,
kung sino yun.
Nakita natin.
Tapos kanina nga, si Congressman Fariñas didn't like the word G-O na, so, inask niya na kung pwedeng ano.
Pero din sa pangkalatan, ano yung dapat maiwan sa mga manonood ngayon sa nangyari ngayong araw dito sa impeachment trial na ito?
Na malapit na yung katapusan o malayo pa rin. Mukhang aabot pa ng May, no? Kasi kung March 12 magre-resume, yung defense...
May sinabi sa parang 15 days pa yata pag-aaralan.
Mga 2-3 linggo, pero may recess, di ba?
Okay.
Sa March 23. At mukhang wala namang plano na ika-cancel yung recess, di ba? So sa May pa magre-resume. So matatapos siguro, baka aabot tayo ng June para sa verdict, di ba? Parang ang tagal.
Masyado matagal yan.
Sana naman i-reconsider ng Senado na... kailangan yan, joint yan na decision ng House at Senate na maaari siguro iklian ng konti yung kanilang recess.
Hindi kaya may pagsadyang tagalan dahil minsan yung attention, no? Tama rin ng tao at...
dapat nga tapusin na kasi tinatamad na talaga yung mga tao. May nakita na akong scientific polling dito yung kay Mr. Juni Lailon. I mean, at makita mo hindi ganun ka-interesado na yung mga tao, no? Kasi nagtagal na masyado, no? I mean, tapos, di ba, yung karamihan sa tao, they're willing to give this to the Senate. Para sa kanila, kayo na ang magpasya dito, no? Parang 85% ata parang tatanggapin kung anumang desisyon ng Senado.
Siguro rin kasi yung mga pinag-uusapan na mga allegations dito sa punong mahistrado ay hindi masyadong naarok ng karamihan.
Naging napaka-technical.
Naging
napaka-technical. No? Sa tingin ko, at yun ang siguro isang takeaway din na napansin ko, no, na dun sa discussion yung discussion kung nag-rest na ba, nag-withdraw, na ganyan. Babalik ka dun sa yung kaso na pinisenta ng prosecution, no? Yun ang dapat ngayon kasi kailangan natin i-assess how strong is the case of the prosecution, di ba? Kasi tapos na sila essentially, di ba? At dun mo makita masyado sila nag-present ng very technical case na mahirap i-appreciate. Now, yung value nun, tulad sinabi ko kanina, meron na silang napatunayan na medyo discrepancies o gaps sa SALN ni Chief Justice Corona.
So now it's up to the defense para explain kung bakit may mga ganong gaps.
Ng defense yun, di ba? Including, I think, bringing Chief Justice Corona to testify.
Kanina din tumayo rin si Senator Cheese Escudero. Tapos sinabi niya na pinload niya yung idea na hindi ba dapat i-amend yung mismong complaint because you're in fact abandoning yung ibang articles of impeachment.
Tagal na sinasuggest nila.
Pero hindi...
dapat ba talagang i-amend or pwede naman?
Hindi naman to kaso civil or criminal case na kailangan mong gawin yun. No? Enough na yung sinabi ni Senator Enrile, you write a formal statement withdrawing, di ba? Or abandoning, whatever. Sabi niya, kayong bahala pumili ng words. No? Balik tayo, no? Yung nature ng impeachment proceeding is that it is a political proceeding, di ba? Hindi siya criminal, hindi siya civil. Sa tingin ko nga, mas administrative siya than anything else, di ba? Kasi tungkol siya sa fitness ng isang tao sa office, no? In a way, sa postmortem dito, ang nakikita ko, most probably sasabihin ko, ginawa natin, ginudicialize natin, to borrow a term from my colleague sa UP College of Philosophy, Professor Hilbay, no? I mean, Florin Hilbay, this really brilliant colleague of mine sa UP Law. Masyado natin ginudicialize, no? Ginawa natin tulad ng judicial proceeding ang impeachment. Pero dyan, para sa akin, hindi ang kasalanan ng Senado, honestly. Ang tingin ko ang pagkukulang, ang mali doon, nandun sa prosecution. Because they had to use the trial to get evidence, di ba?
Yes.
And then now have to present it. Kailangan na i-present. Kailangan naman yung Senate mag-decide ng admissibility or not, di ba?
Whereas if you compare it with the previous impeachment trial, yung impeachment
actually,
trial...
kay Arab ganun din, di ba? Kaya nagka-problema kay Arab. Kasi again, wala ding evidence, di ba? Ginagamit yung trial to get the evidence.
Fishing, expedition.
Ang comparison talaga dito, yung US, yung kay Clinton.
Na 18 days lang daw yung trial.
Kasi by the time dumating sila sa Senado ng Amerika, nandun na yung evidence.
Tapos na.
Hundreds of boxes worth of evidence.
And everything was admitted?
Admitted but not given value, di ba? Kasi yung pag-weigh ng value nun, up to each individual senator, tulad nito.
Pero hindi na in-object kung
nag-object, pero it's up to the senator to decide accept it or not. Kasi individual senator decision yun, di ba? Kahit dito naman, kahit na i-disallow yung evidence, di ba? A senator can still appreciate it. Kasi wala naman siyang, hindi naman ito na ang debate naman ito, when they debate it, so I hope they will debate it, di ba? They will debate on their own perception of what is the truth, di ba? Yun naman ang given dito Not on the technicality of what is admissible evidence or not.
Nabanggit mo yung UP, may 500 pala na kakampi rin si Atty. Aguirre. Baka tungkol doon sa survey, baka magpalabas na rin ng statement yung nagpa-survey dahil matindi rin yung binitawan ni Senator Santiago.
Isa din yun.
Oo. Ano ba yung sinabi?
Strong words doon sa parang dahil sabi parang wala na yung karakter ni Chief Justice Corona doon sa tanong doon sa naturang survey.
Kaya patuloy sabi ko, diniskan ko kasi marami ding beses gusto ko yung sinasabi ni Senator Santiago. Meron ding beses na hindi ayaw ko yung sinasabi niya, di ba? So hindi ko pwedeng piliin Piliin ko na lang, tanggapin ko na ganyan talaga siya. I consider her a national treasure. Ini-enjoy ko na lang siya. Hindi ako magagalit kung nagdi-disagree ako sa kanya. Dapat ganun yung treatment natin sa mga taong tulad gano'n.
Kumbaga yung character ng isang tao makikita rin on how he or she reacts to certain things.
Exactly.
So babalik tayo sa square one na dapat nagkaroon ng tinatawag na preliminary. Di ba yun ang nire-request ng defense panel nung araw na hindi naman napayagan ng impeachment court? Yung preliminary investigation bago itinuloy ito. Malaki ba talaga ho ang na walang kasayangan kung natuloy yung preliminary
malaking diferensya kung nagkaroon ng or kahit na yung preliminary hearing or pre-trial, di ba? Malaking o kahit na nga sa house mismo kung nag-hearing
sila.
Kasi they could have admitted evidence on their own terms, di ba?
Tama.
Siyempre overrule nila lahat ng objections ng ng defense, di ba? Kasi nga nag-gather pa sila ng evidence, di ba?
Mukhang akala nila kasi magre-resign. Yun ang
sa tingin ko.
yun yung kwento ng ibang mga congressman.
Sa tingin ko
mape-pressure nila. Dahil meron silang sinundan si Ombudsman
Mercedes
Gutierrez na nag-resign.
Kaya lang alam nyo, okay lang yung strategy na yan kung hindi mo masyadong demonize yung tao, di ba? Sa tingin ko nag-over-demonize sila kay Chief Justice Corona na yung tao, nag-decide siya na eto na yung line. Wala na naman, sinira nyo na yung buhay ko, sinira nyo na yung pangalan ko, kalabanin ko na yan. I will get vindication for this, di ba? So, nawala yung space na sana, di ba? Yung spasyo na sana pwedeng mag-resign, di ba? Na pwedeng mag-retire. Yung ganon. Di ba alam naman natin si Ombudsman Gutierrez kasi reported naman, di ba? Nakakuha siya ng deal, di ba? Na napabor din sa kanya. Retirement, walang kaso, di ba?
Hindi na nahabol.
Alam nyo, yung mga ganyan, societies have to move on, di ba?
Yes.
Kasi kung hindi naman, buong 20 taon, ito ang pag-uusapan natin, di ba? At napapako tayo sa nakaraan kung hindi natin gagawin yun. Kaya wala akong problema kung may agreement.
Okay. So pagdating ng March 12, ang limelight ay nakatutok na ngayon sa depensa. Ano ma-expect po natin?
First, I expect a very professional, disciplined defense. No? Kasi consistent the way they have operated through
masanay sila yata
I mean, I may disagree with them, but bawa ko sa kanila. They are good. They are very focused, di ba? Alam nila anong ginagawa nila. They will have to defend essentially the SALN. Okay. Sa tingin ko yun lang. Yung bakit ito yung SALN ni Chief Justice. Bakit lumabas na ebidensya na may mga ganitong kondo na hindi wala doon, may mga bank accounts na wala doon, di ba? And sa tingin ko, the best evidence of that, at pinapalabas na ng mga senador din na yun, is the Chief Justice himself.
Siya na mismo
to come and say, saan nanggaling yung pera na ito? Saan nanggaling yung pera para bumili ng kondong ito? Saan nanggaling? Sa tingin ko, wag nang pag-usapan, hindi na kailangan i-defend ill-gotten ba ito o hindi. Kasi pagkakamali din yun ng prosecution nung una na
hindi po pwedeng sabihin niyang na-overlook lang
nila
niya
na ill-gotten, na magnanakaw, di ba? Wala naman silang ebidensya for that at all, di ba? Importante lang na may discrepancy at may non-declaration.
Can he say that he just overlooked it? Na-overlook lang?
Pwede niya sabihin yun.
Depesa na niya yun.
And then, ang question ngayon ng
bakit continuously na-overlook?
Pattern ba ito, di ba? Kung pattern yan, convictable ba yan o hindi, di ba? Dapat bang o removable ba from office? Kasi pwede kasing sabihin ng mga senador, di ba? May gap, may discrepancy. Sa defense nyo, sinabi nyo na medyo may pagkukulang lang dito, pera talaga ito ng asawa niya, pera talaga ito, hindi lang nakalimutan ng ito. Ang tanongin, pattern ba yan? Di ba? Kasi kung isang maliit lang na bagay maaring mapatawad, pero yung Supreme Court, pinakita niya ni Chief Justice Panganiban in a column last week, no? Has been very harsh, ha? Kahit konting pagkakamali mo lang ng SALN mo.
So meron ng natanggal, naparusahan dahil mali yung pagkakasulat nila sa SALN.
Stop na na talagang naparusahan.
Marami na.
Lalo yung kumuha ng 2 sweldo, di ba?
In fact, kahit hindi mo ma-declare na meron kang kamag-anak inside government, ay pwede ring sabihin makasuhan ka or
actually napaka-stricto ng yung tinuturo kan sa UP Public Officers Law. I mean, napaka-stricto ng SALN. Sa tingin ko nga, never mind the particular case, it's stupidly strict, di ba? Almost every government official, ito yung problema. Almost every government official pwede
employee.
Pwede mo mabuli na SALN omission, di ba? Maaring hindi kasalanan o hindi. Maaring intentional o hindi, di ba? Kasi napaka-stricto niya ng yung mga talagang walang pera, di ba? Okay lang kasi, di ba, wala naman talaga silang marireport. Pero kung may lupa ka, may negosyo ka, ay napaka-stricto ng ating SALN.
Public accountability.
Okay.
Maraming salamat.
Maraming salamat po sa ating legal expert na nakasama natin ngayong hapon, si Dean Antonio Lavinia ng Ateneo School of Government. Thank you, sir. Thank you,
Dean. At yan ang pinakaseryong balita kaugnay sa impeachment trial ni Chief Justice Renato Corona. Ako naman, Arnold Clavio.
Huwag po kayong bibitiw sa patuloy na pagtutok ng GMA News TV sa paglilitis ng punong mahistrado ng Korte Suprema. Ako po si Cara David at ito ang The Chief Justice on Trial.